why you think they're a good idea or a bad idea. We'll take testimony from those that are for each bill. Then we'll take testimony from those opposed, and then by those that are neither for nor against. We ask folks to keep their comments to 3 minutes if possible, and then we'll have time to ask questions of each person if there are questions from members of the committee. I'd like to also remind everybody that we are being broadcast live on YouTube as well as through Zoom. All of our comments are public record. Everything's recorded and broadcast on the internet. For members of the public that haven't signed up yet, if you'd like to speak on any of these bills, please sign up through our committee clerk, Avery Page. And so with that, I guess we will begin with, I have the bills here in front of me, but we'll start with Senate President Jackson, who's here to introduce the first bill. Is President Jackson with us? Do you know if he's with us, Avery? Is he going to be?
I'm not seeing him on yet.
I know he did want to speak first because he had a scheduling issue, so
He's coming in.
Oh, there he is.
Hello.
Welcome, President Jackson.
Well, thank you. We've been watching you get going here, so I really appreciate the opportunity. Senator Chipman, Representative Terry, and members of the Joint Standing Committee on Taxation. My name is Troy Jackson. I have the great honor of serving as the President of the Maine Senate, and I also proudly represent District 1 in Northern Aroostook County, stretching from Caribou North to the St. John Valley. As members of this committee, you probably know, and I believe Representative Matlack educated me last year on the true meaning of cabotage. My experiences working in the logging industry in northern Maine initially led me to run for the legislature many years ago. I believe then, as I do now, that Maine loggers and truckers face an uphill battle competing against their counterparts in Canada, who benefit from a favorable exchange rate and government-sponsored health insurance. This dynamic has depressed wages for Maine people working in the woods and handed large landowners extraordinary power in the industry. The bill I'm presenting today is an attempt to correct yet another injustice to Maine workers. Throughout my time in the industry, we've been told that Canadian truck drivers are not allowed to practice what is now referred to as cabotage, or point-to-point truckloads in the United States. It is generally accepted that drivers are allowed to deliver international shipments into the U.S. and then pick up a load to be delivered back to Canada. However, at no time can a driver deliver their initial load in the U.S. and then pick up a subsequent load in the U.S. and deliver that load to the destination within this country. Taken as a whole, my conversations over the past few years with the Maine Department of Labor, customs directors in Aroostook County, Maine Port Authority, and others have made it clear is that there's real confusion as to why the federal government is allowing the practice of H-2A visa program. It's my understanding that the H-2A visas exist to allow farms to have short-term workers pick crops that would spoil in the fields if they were not harvested in a timely manner. Under this scenario, truck drivers would be moving products in the fields and possibly to a processing or storage facility not far from those fields. Let me assure you that trees in Maine are not spoiling in the fields. In fact, the older and bigger they get, the more profitable they become. I strongly believe that H-2A visas were not intended for this purpose, and to allow this practice is completely at odds with Homeland Security rules on cabotage. There is absolutely no way that Maine workers can compete with this interpretation of federal law. Allowing drivers in this industry to misuse the H-2A program also flies in the face of one of the overarching principles of allowing H-2A visas in this country, and that is to protect the wages and working conditions of U.S. workers. This issue has only become more glaring than ever during the pandemic, when Maine wood haulers need more work than ever. Last summer, I filed a complaint with the U.S. Department of Labor concerning the practice of cabotage in the logging industry in northern Maine. As some of you may have read, I also spent a day with a reporter from the Bangor Daily News to highlight the problem and bring attention to the lack of enforcement over this breach of federal law. This bill is before you based on the amendment that passed this committee with bipartisan support in the last legislature, just before we adjourned due to the pandemic. The proposal recognizes the need for our state to take a stand for Maine workers in the logging industry by ensuring that large landowners respect federal law on the practice of cabotage. Any landowner that owns 50,000 or more acres of forest land and allows the practice of cabotage with products harvested on their land becomes ineligible for the Maine tree growth tax law following 2 previous violations. So you would have to show a pattern of disregard for the federal law before you would even have to worry about losing your tree growth benefit. Additionally, those landowners engaged in the practice may not receive certain tax incentives, state grants, or state funding. I also want to note that my staff and I have worked with Maine Revenue Services to address some of the potential clarifications and concerns they have had with the language as written. The major concerns were around who would handle prosecution, enforcement of the violations, and the severity and length of ineligibility for state tax credits and grants funds. As the committee works this bill, I want to make the following suggestions to help clarify some of these concerns. The prosecuting authority for landowners' violations of cabotage should be housed under the Department of Agriculture, Conservation, and Forestry. Currently, the Department of Labor has an MOU with DACF for them to do inspections. And the department already has their forest rangers that do timber trespass, timber theft, and all these different things. So it certainly fits in line with the enforcement arm of the Department of Ag, Conservation, and Forestry. The language that would be enacted in Section 2, 10 MSRA Section 2364B in subsection 7 regarding the prohibition around transport should be directed in a way that the landowner positively affirms that the transport is legal. This could potentially be done using a box on their trip tickets where the landowner verifies that the transport is legal. And I'll show you some of these trip tickets in a moment. The length of the removal of a landowner from the Maine tree growth tax law should be 2 years following the ineligibility from the program. That's in lines 30 and 33. I certainly think that 2 years shows that this is a serious issue and draws attention to something that people have consistently thumbed their nose at. For the language regarding the loss of state awarded grants or state funds, lines 34 and 37, should be clarified to mean only business grants or state funding, not personal grants or state funding to an individual landowner, for example. For example, if a business entity otherwise qualified a carbon reduction grant, but received a third violation of cabotage law, that entity would be disqualified for the program for 2 years following, in a similar fashion to the length of time that they would be disqualified for the Maine tree growth tax law. For far too long, Maine workers in this industry have faced challenge after challenge. This bill asks landowners to do some very simple things: follow federal law as it relates to the practice of cabotage, and recognize that the misuse of H-2A program, and make sure that they give Maine workers a fair shot. So I have a slideshow, but I wanted to explain to you why we put together this slideshow since, well, I mean, really since my whole life, but maybe just since Friday. I've heard an awful lot from the industry and the department and the administration about how this is not happening And then when I explain to people how it is happening and that there's documented proof of it, then it's, well, there's a lack of truckers. Which makes no difference if there is or not. The law is the law, and it's up to this state to make sure that there's enforcement of that. I also hear from the department that says that landowners have no control over this issue, which is a complete farce. I understand the industry very well, and landowners dictate to people all the time where to go on a daily basis, where to haul, where to pick up, and where they're going to deliver. The idea that they don't know who is picking up this lumber at any one time and any one day is a complete joke. That is not at all how this operates. And I also read in the department's testimony that it makes no logical sense to tie these things together. Well, I believe you're going to hear from Representative Myerton, who actually instituted the tree growth program. This was the very reason why we gave a tree growth tax break, was to keep land and forest products production. So if the harvesting and hauling of forest products is not at least tied to the tree growth program, then I don't know what else is. But the reality is that this has been a long-term problem that has consistently been brought forward by people. And obviously this is a big hammer to swing, but I think it's time that landowners understood that this is not something that can be swept under the rug. You know, and I can provide for the department, but in 2017, after a number of years of fighting with Governor LePage, you know, I invited him to come to Northern Maine and meet with the loggers up there. And to my surprise, he took that opportunity and came, and you know, there was probably 80, 85 people that spoke there and spoke extensively about this issue. I mean, it's documented, it's filmed. Susan Sharon, NPR, was there, you know, and what was striking to me at that time was one of the landowner industry people showed up, and even though I asked them if they would leave so that people could speak freely without the fear of reprisal, and they wouldn't, people still spoke about this issue in front of them. And the issue is under that administration and under this administration, people are not taking this seriously, and there's only so many times that somebody's going to stick their neck out before they're going to get it chopped off and quit speaking. You know, this weekend I heard from a former classmate of mine that her husband is a large contractor for one of these landowners, and she told me that she was wanting to know if I knew of anywhere where they could get cheap health insurance, because she couldn't probably drive to her job anymore, you know, before she turns the 60s, become, you know, her age. That's what's going on in the industry, is that oftentimes, you know, husband and wife team, the wife picks up the health insurance for the couple, for the family. In an industry that is, you know, doing as well as this, and you know, workers that are working as hard as they are, they can't provide health insurance on the logging side of the business, which is insane. And so, you know, it would be easy, after getting my head slapped around so many times on this issue by all these different administrations, to give up on this. But it's pretty hard to give up on those people that consistently see a law that is being broken, understand that there's an industry that is being taken advantage of, understand that it doesn't matter under Democrat or Republican administrations, there's too much closeness to the landowners, too much closeness to the Forest Products Council. And every time that one of these things happen and you go forward and ask, you know, for somebody to look into this, that, I mean, literally this summer, and I'll show you the slideshow, literally this summer, when I asked the Department of Agriculture, Conservation, and Forestry, they told me that they had talked to the landowner said it was legal, therefore there was nothing they could do. So I want to show you this slideshow, because you're going to hear after me that this is not happening. And I can't bring the North Main Woods to you. Or I can't bring you to the North Main Woods, but I certainly can show you what, we've started firsthand and let somebody try and dispute that that's the case. So if you indulge me here for a moment.
Excellent, Senator Jackson. Just so you know, we can't see your video. I don't know if that's something on your end or our end, but just wanted to bring that to your attention. Not the video you're about to show us, but the video of you speaking.
I think we need the ability for it to be shared.
Okay. You mean the video you're going to present to us?
Our hand is raised and we need to be promoted.
Yep.
Yeah. Avery,
Avery,
can you let him in as a co-host so he can share his screen?
I'm on the phone with IT right now. I don't have the option on my end to make him a panelist or a co-host right now. Not sure why. And I couldn't get any answers from the Zoom support in LIO. So
Okay.
I'm trying to get a hold of IT right now so they can
Okay.
try and diagnose what's going on.
So I
Yeah.
just promoted him to panelist.
oh, we see you now, Senator Jackson. You're on the screen here. Don't know if that makes a difference or not.
We're pulling it up here, I guess.
Okay, great.
There we go.
Looks like something's starting here.
Yeah.
Excellent.
So this is the Homeland Security guideline for cabotage. It's not something that I made up or anything like that. This is the actual Homeland Security package talking about compliance for commercial motor vehicles engaged in cross-border, and I can provide this to the committee. But in there, as you see, movement's not permitted for the driver. And this is what you'll hear today, and this is what the department has actually told me when they spoke to the landowners and they spoke to Forest Products Council. They were told that the owners of the trucks that were doing this were actually U.S. corporations. So it was legal, which is untrue. This is Canadian companies that have just filed for incorporation in Maine. They're headquartered in St. Paulfield and other places across into Quebec. But it doesn't really matter because it's not about the truck, it's about the driver. That's what violates cabotage. And as you can see, drivers may not pick up at a shipment at one U.S. location and deliver that shipment to another location. Drivers may not reposition an empty trailer between 2 points in the United States, and the driver did not enter with or depart that trailer. That is what's happening consistently. And like I said, all four of those points, it's the driver, not the truck, not the owner of the truck, it's the driver. Just to make that very, very clear. So here's one of the trip tickets that, and this was actually pulled by Department of Agriculture, Conservation and Forestry, one of the forest rangers doing a inspection. And as you can see, they talk about this being such a hard thing to enforce and all that, but these trip tickets are really, the holy grail. I mean, not only are they how the chain of command, where the chain of custody, but for all of them that are have forest stewardship, FSC, ISO, SFI, these trip tickets show where the load was picked up, where it was cut, and where it was going. And as you can see, in this case, the driver name is Marco. Where the load was dropped off was in Portage Lake, which is in my district, clearly in Maine. And you can see right underneath, well, in two places, the township, Township 5, Range 13, which is in Maine, and what we refer to it as Blue Pond Road. So the load was picked up on the Blue Pond Road in Maine, and it was delivered in Portage Lake in Maine. This also is the ticket that actually shows the weight. You know, after the driver delivers to the mill, they get a trip ticket and what the weight was. So this is the driver, and I could have picked a number of drivers, but this one here actually has had I think a 3-year run that he's been stopped by the Forestry Service and you know, checked. What he could do and what is legal is to pick up a load in St. Paulfield and deliver it down at, you know, point B. So it'd be leaving Canada, coming into Maine and dropping off. That is allowed under international law. What isn't allowed and what is happening is the drivers coming in from St. Paulfield or from Canadian Point and picking up at A, let's say the Blue Pond Road, and delivering at B over in Portage Lake. That whole trip is within Maine. That's point to point in Maine, which is not legal under federal cabotage law for a Canadian driver.
This is Nashville Plantation in Maine, right alongside of Ashland and Portage Lake. Definitely part of Maine. It's almost 8:30 Tuesday morning. Like, try and document this so Forestry Service could actually pull the trip ticket for this load. He just pulled through the Irvin Wood Yard. He's going over to the Seven Islands Wood Yard. We're gonna go over and film him going on the scale there.
Mr. Chair,
Yes, Senator Pouliot.
is it a new practice for us to have like
Okay.
presentations being
There he
made
is,
to
Gene H.
committee?
Trucking, pulling into Seven
First I've ever seen a
Landfill.
video shown to committee before.
Yeah.
Wade.
We haven't had the ability to do
Seven
videos
Islands
before.
Log
We have had people present charts and graphs and things like that, visual things during their testimony to introduce bills.
Okay. This is what it's all about right here. Right now in times people are having a hard time, people being shut off.
So what you're saying is it's now allowed for anyone that's giving testimony before our committee to be able to show us video?
I don't see anything that prohibits that. Certainly, it's like a sponsor is introducing a bill. If this is part of their testimony to introduce the bill, I don't see anything that prohibits that unless you know of something in the rules that it does. I'm not aware of anything.
To my knowledge, you know, in the 8 years that I've been in the legislature, we've never had the ability for a presenter of a bill or anybody who was testifying on a bill to show any kind of props or videos or any kind of presentation other than handouts to the committee.
So Senator Chipman, I certainly obviously didn't ask the senator, but the idea that we've never had charts or graphs or maps presented at committee, I've certainly seen that consistently throughout my time. Certainly this video, if we've not been allowed, you know, maybe we need to take that up in legislative council. But the reality is, the reason why I wanted to show it to the committee is because you're definitely going to hear real soon that this is not happening in northern Maine. And like I said, can't bring you up there, but I can show you what actually is happening in a very short clip, so that you can you know, certainly question the people that ask why or that this is not happening. Honestly, I never once thought about the reality of if it was okay to show a video or not. But what I did think about is all the testimony that I know is going to come that says this is not happening, and making sure that the committee knows that it is actually happening. That video, I shot that on August 11th myself. Then I asked Maine Forestry Service to go and pull the trip tickets. And within a 2-hour period, they pulled 3 separate trucks from Canada with all H-2A drivers dropping off there in Portage. So if I broke the rules of committee, certainly sorry, but I thought that making sure the committee had what's actually going on was important.
And I guess, I mean, I've been serving since 2010, and I was a co-sponsor of a bill with a representative from Augusta who presented it was a projector. There was a video or a presentation on a projector that was presented in a criminal justice committee, I think back in 2012, and I served on the Environment and Natural Resources Committee. We had some things presented visually on a projector to us in that committee back in 2013 or 14. I mean, I think it has happened, maybe not exactly like this, like a video, but things have been presented visually, certainly by sponsors of bills. I'm not aware of anything that prohibits that. If there is anything, I'd like someone to bring that to my attention, but I personally don't see an issue if there's nothing in the rules one way or another allowing a sponsor of a bill to present something to us visually if it adds information that's helpful to us as we consider the legislation. So I guess with that, we can certainly talk about this more as a committee at another time, but is there anything else you'd like to continue with, Senator Jackson, with your presentation?
Well, just, with all of your conversations last week about, or the other week about small businesses and PPP loans, I would have thought that making sure that Maine businesses, they're, getting passed over for Canadian truckers would have been important to this committee, and showing that just would have been important. But we certainly taken an advisement that maybe this isn't the right way to do it, but I don't know how else you would have been able to see it other than go up there. And so now you know.
Yeah. Okay, great. So if that concludes your testimony, is there questions from members of the committee for Senator Jackson? Representative Kryzak, you have a question for Senator Jackson?
Yeah, I do.
Sure.
Senator Jackson, has there been any change in it since the Canadian border has been closed because of the pandemic?
Well, that's a great question, Representative Kryzak. No. Apparently, Canadian truckers are considered essential, so they can cross at any time. My district having a big part of it on the St. John River border. We've had a lot of people ask me about being able to get into Canada to see their friends and relatives, and they really don't understand why the trucks can keep rolling over when they can't go over and see their, like you said, parents or whatever. So no, they and matter of fact, in August, whenever I shot that video and went to that Bangor Daily Reporter, there was a huge layoff in the industry in my area of truckers and cutters because the market was bad. That video actually was when a whole bunch of my constituents were at home, not being able to work, and they kept the Canadian trucks hauling throughout that entire time. And we presented that at that time to the department here at Ag, and that's when they went back to the landowner and asked them if it was legal. The landowner said yeah, so they just let it go, which was amazing to me that in a time whenever people were laid off, not working in a pandemic, they didn't get those opportunities. If the industry, throughout this entire time, we've heard about how the reason why we need H2 workers is because of the shortage in the industry. If people are laid off because the market is bad, I can't understand for the life of me why we allow H2 workers to come in and take what jobs that are left.
Thank you.
Representative Gramlich, do you have a question?
Thank you, Senator. Thank you, Senator Jackson. So if I'm understanding this correctly, the practice that is occurring really puts our forest industry and hardworking Mainers in northern Maine at a disadvantage. Am I understanding that correctly?
Well, that definitely is my opinion, and certainly a big reason I think why I've been elected there throughout this time. And in 1998, the exchange rate was upwards of 55% on the dollar. It certainly has gone, up and back. I think now it's a little over 30%, but that's a big advantage for those workers. Like I said, not having health insurance. Most of the people that I know in the industry don't have health insurance. If they do, they're not getting it from their logging job. They're, like I said, they're getting it hopefully from their partner or their wife in another industry. So yeah, but what's really troubling about this is when those workers, and I want to make it very clear, and I've said this consistently, I mean, the men that are hauling that wood out of Canada are good men and good workers, and they're doing what they need to do to survive. But it's just an unfairness that I just can't turn away from. But what really is striking is that they leave St. Paulville or St. Joe, Staquam, anywhere on the northwest border, and come in and pick up a load in very rural and unorganized territory and deliver to places like Ashland, St. Paul, Portage, and then they subsequently pick up another load and go back. So they're hauling both ways, which is rare that American trucker gets that opportunity. So that becomes a real disadvantage. They can cut the rate. They can do it for less. They're hauling both ways. They have the exchange rate. They don't have to worry about the health care. And it depresses the wages, which again is one of the premises of the H-2 program, is you're not supposed to be able to depress the wages. But if they weren't allowed to do that, they could still come in and deliver a load and drop. But when they pick up in Maine and deliver, that becomes a real hardship for Maine truckers.
Follow up, if I may.
Sure, go ahead.
Thank you. Little known fact, I actually have 5 years working in logistics and in the trucking industry, having worked for FedEx Freight for a number of years. So I do have a keen understanding of what you're referring to, Senator Jackson. And I just, not to make a testimonial, but I'll ask, would you agree that having a strong industry in the forest industry and assuring that this industry remains strong is the backbone of a strong Maine economy overall? Would you agree with that? Is that a fair assessment?
Well, I would say that, for all industries, but certainly those heritage industries, fishing, they're having a hard time with the right whale issue, wind things. The last year, this committee did, in my estimation, a great job with the McCrum bill, trying to help dale processing in northern Maine, or in Maine. But this is, very, very problematic. When you don't have the ability to negotiate for fair rates, because you have a whole subset of workers that can come in and undercut you, in my belief, illegally. Even if you can believe that it's okay for these truckers to come in and do point-to-point hauling in Maine, even if that is legal, the fact that they're undercutting American wages and depressing them is a violation of federal H-2 immigration law. And there's no way that you can argue that they're not undercutting them. They can do it for less, and they are. And it is a long-term problem that under different administrations, people wouldn't take a stand. These departments have, like I said, a closeness to the industry. They've already, wrote their testimony and talked about how this isn't happening, how it's, it's no wonder. It's no wonder people have given up, with government inaction. I certainly understand how people can, just think that there's just nobody listening. And I don't know how much longer I'm going to do this. It's been a long time, but it really upsets me that something so clear as protecting Mainers, Republican and Democrats alike. And we're not going to do that. We talk about small businesses, but for whatever reason, these ones don't seem to matter.
Representative Sachs. You have a
Thank
question?
you, Mr. President.
Good morning. Thank you, Senator Chipman. Good morning, President Jackson. So being new to this issue, what I'm hearing quite clearly based on your last statement, especially that this bill proposes significant state penalties in an effort to enforce a federal law. And I'm wondering if the Department of Labor responded to your complaint this past summer.
We filed a complaint with the USDOL. I think that was our second one. And I have called the head of the U.S. Department of Labor, Brian Pasternak, numerous times. We can't get them to even talk to us. And I spoke with Commissioner Fortman about this, and I think in the last 2 months, they've reached out to them and they can't get them to respond either. Like I said, with the Department of Ag, their response has been, well, it's legal because landowners tell us it's legal, which is just shocking to me that that's how we're gonna play this. But the reality is that I've come forward with this bill twice now to this committee because it is happening. I mean, it's undoubtedly happening, and everything I see shows me that it's either illegal under cabotage or it's illegal under adverse effect under the H2 program. And the only way to stop it at this point is to make some type of stand. And you're going to hear how this is overly burdensome and such a huge penalty to landowners. Well, the landowners know what's happening. I mean, without a doubt, I've called them, I've talked to them, I've offered constituents of mine to do the hauling. They know what's happening. It's the reason why it happens is because it saves them money. And that is the reason that it continues to happen. The only way that we're going to get a change, if we want to change, and obviously some people may not want that, is to have something that actually penalizes the people that are allowing it to happen. And this doesn't even do it at first blush. I mean, you got a 3-strike provision in here before you're actually going to get, the big penalty. But it's clearly, like I said, happening, and it's something that I just, like I said, I can't look people in the face when there's something black and white in federal law and look them in the face and tell them, well, I'm sorry, but nobody wants to take a stand on this. Nobody wants to actually enforce it. When they all know that there's no way that they can work any harder, any more hours a day. I mean, I've never seen a group of people, husband and wife, struggle any harder to make things work. So, I mean, I'm not, I mean, I think this week I've been called a one-trick pony. I beat the same drum all the time. Well, I'm going to damn well beat that drum because there's something the matter that we don't want to protect the main businesses, the main workers that are working their ass off on a daily basis.
Right, and I definitely hear the frustration. Again, my question was just around the mechanism of significant state penalties enforcing a federal law and sort of the work around that. Has our federal delegation been any response to you as well? That's my other
I've
question.
worked with Congressman Golden quite a bit to try and get the federal government to do their job. And obviously, these past couple months have been quite an upheaval for a lot of different reasons. So, I mean, it's probably not taking the precedent. But let me, just speak to that point. I mean, I categorically disagree with the fact that, and I'm not saying that you're saying this, Representative, but because this is a federal law, then the state of Maine has no role in protecting Maine loggers and truckers. If we know that it's illegal, if we know that it's happening, if we know that there's an adverse effect and our people are, put in a situation where they are having a harder time to compete, I think it's incumbent on us to use any mechanism that we can to enforce that federal law and make sure that they have the protections that they deserve. Federal inaction is not a reason for state inaction.
Duly noted. And just for the record, Mr. Chair, I would have appreciated seeing the video. I don't care what bill it's on. I think the additional information is of a benefit. So thank you so much. And President Jackson, I don't know if you're able to send that to the committee afterwards, but that would be most appreciated. Thank you.
Representative Terry, you have a question?
Yes, thank you, Mr. Chair. Thank you, Senator Jackson, for bringing this to us again. I just have a question that I'm not sure if I had asked last time, but I know we're sort of in a unique position with our forested lands being on a border, but are there other states that struggle with this particular federal law, like, perhaps in the Pacific Northwest or even New Hampshire? Like I said, I know that we're definitely in a unique geographical location for this to be happening, but are you aware that it happens anywhere else?
So, I think back in 08, 09, current Governor Mills, when she was Attorney General, brought forward some of our complaints. They were a lot similar. A group of us actually went into the North Maine woods and videoed a bunch of H2 workers. In that situation, what was happening was the wife was forming the corporation, and then she was bonding the husband to come in and run their equipment here in Maine. Under that scenario, Governor Mills, the Attorney General's office, took 3 companies to court and found them in violation of H2 law and proof of ownership here in Maine. And some of those companies actually left Maine and set up shop in New Hampshire. Because I remember the New Hampshire Department of Labor calling me and talking to me about it, and I asked who it was, and when they told me who it was, they were the companies that we had kicked out of Maine similarly. Since that time, those companies are back working now in Maine currently, and they're one of the ones that actually are violating cabotage. So the only thing that I've ever heard was that one situation where one of these companies went to New Hampshire, and for the first time ever, New Hampshire started using H2 workers in the logging industry. I've checked, I've dealt with Washington, I've dealt with Michigan, Oregon, numerous states across, and I've never heard of the H2 program being used in logging. But I guess you'd really have to understand, the problem of the North Maine woods. Like you said, on the border, some of these places are on the Canadian side, are more urban centers where you have to go 50, 60 miles before you start getting to places in Maine. And so I think it definitely is a problem about a sight out of mind. But like I said, it's still, the stuff that I provide you today and the other stuff I have, it all came from inspections with the Department of Ag. Those are not things that I could get or anything like that. That was inspections that came from the department. So the department knows it's happened. They've been stopping and inspecting these trucks. But again, it's to answer your question, New Hampshire did it for a very short period. They're not doing it right now because the company that was asking for H2 workers is actually in Maine asking for H2 workers.
Interesting. Okay, thank you.
Senator Carmichael has a question.
Yes, thank you, Mr. Chair. Thank you, Senator Jackson. I got a couple of quick questions. One is that truck that was in the video you showed, was that one of the ones that has corporate, has been incorporated in the state of Maine, or is that?
Yep.
It is?
So that is actually G&H trucking, and that's on the trip ticket that was provided. Well, that's in that screen. The video, or excuse me, the presentation that will get to you. But that driver, like I said, has been stopped in 3 years in a row. But I mean, I could take you to northern Maine today, and we could stop that truck again. And basically, what that is the company called Transport Regie out of St. Bonfield, and then they subsequently created G&H Trucking, which is the owners of Transport Regie. They basically just have to file and get a U.S. corporation. And in their minds, I guess in the landowner's minds at that point, it makes it legal. But again, it comes down to the driver, who's clearly an H2 worker. That's documented here too. We can provide you, out of Canada. So that's one of them. There's numerous companies that are doing that. Just happened that day, like I said, I was able to video those trucks and then have the Rangers Forest Service go and pull those trip tickets, and then I had to file a freedom of information request asking for the tickets.
Okay. And I also have a transportation company. I haul mail for the Postal Service, and and because it's mail, I have to follow interstate commerce laws. So I like your intent. I have a problem because if I break laws, then we can't hold the post office accountable for the laws I break. So I guess I understand what you're trying to do, but I have a problem with not punishing the trucking companies, but punishing the person who hired them. So, that gap, I guess I'm having a problem with that there.
So I understand your concern there, Representative Carmichael. I mean, I don't know your business model, but I would expect that you're an independent contractor, the U.S. Postal Service, and you have a job and you do the job, within defined role, but you decide, what time you're leaving and things like that. The reason why I think what I'm trying to accomplish here is that in every step of the process, the landowner dictates how this operates, and they know that these drivers are Canadian drivers, and so they can't shed responsibility because they've created what I believe is a bogus independent contractor status here. I mean, they tell them, there's wood on Blue Pond Road, go pick it up, deliver it. It's got to be hauled to Portage, got to be hauled to Ashland. And when they run out of wood there, they tell them where to go next. They know who's doing it. They know the drivers, and the foresters right there making these calls to them. So while I understand the concern, to get at the root of the problem, the landowner is going to have to take the responsibility, and the easiest thing would be for them just to stop having these drivers do these point-to-point hauls in Maine, and then they would never have to worry about any violation, much less lose the tree road. But they consistently, use these trucks, know that all the drivers are out of Canada, which they could even do that, but they can do point-to-point hauls, and put Americans at a disadvantage. And I mean, there's just no other way to explain it other than that, they're calling them and telling them, go pick up this load in Maine and deliver it to another place in Maine. And so to get at the root of the problem, that's going to have to be who feels, the burden.
And a follow-up, if I might.
Sure, go ahead.
So in this circumstance, the landowner would be punished, but the company that's actually breaking the law wouldn't? Is that-
Well, sure. I think where they're going to get punished is at that point, Maine law enforcement through the Department of ACF, they're going to notify the federal government, and these people are going to lose their ability to haul in Maine. That trucking contractor is going to lose his drivers for doing a federal violation. I can't make that happen as a private citizen. I mean, it's going to take somebody in law enforcement actually stepping up and doing their job, and that's where the penalty is going to be for those contractors. Is that when the federal government's notified, they're going to pull their H-2 visa that allows them to work in this country, even on the legal hauls at that point. So that's the penalty for them.
One more, if I may.
Sure, go ahead.
So if we could make that happen, Senator, that would be even better. If we could make what you just said happen to the contractors rather than, trying to find a way to hold the landowners accountable, taking and suspending the company's authority to operate in the United States. Seems like to me that would be it would be a far better answer to the situation. Sure. And we want more land and tree growth. I mean, we want that resource there. I hate to see them penalized that way.
I understand what you're saying, Representative, but I mean, the reality is, like I said, they've created a system where they can shed liability and say, well, it's the independent contractor. But the reality is that they're directing them at all times where to haul, where to drop off, and things like that. In my world, I mean, if the H2 worker wasn't allowed to do that, that would be great. But I don't think it's fair that the landowners get a free pass on something that they have actually created. And like you said, I mean, as far as the land and tree growth, that's fine. I mean, I wouldn't have any problem with that. But I do think it's unfortunate whenever the very people that are being affected by this problem are the ones that are picking up the extra cost of the tree growth and watching those jobs. I mean, watching those jobs go into foreign workers while they're paying the taxes is really hard to swallow. But I certainly understand what you're saying, and I'm more than willing to look at a different scenario. But don't think for a minute that the large landowners don't know what's going on here. They definitely do.
Thank you.
So, Senator Jackson, so is what you're saying the landowners are essentially an accomplice to the problem here, and the problem itself is costing us jobs, costing us income tax revenue to the state, costing landowners money because they're paying more, everyone's paying more property taxes to subsidize those that are in tree growth. And so what we're looking to do with this bill is essentially penalize the landowners who are accomplices to the problem.
Well, like I said, the tree growth program, I mean, I don't have a problem with it on the basis of what it was intended for. I mean, I, as a small property taxpayer, will pay more with the idea that that helps create jobs and sustain an economy. But when you watch Mainers, lose out on those opportunities, it's hard to be supportive of a program like that. So that's why I think important that the people that are creating the program, creating the problem here, are at least brought into it, and they don't get to shed liability and say, well, that's an independent contractor system, and our hands are clean. I mean, that's just not the case. I mean, I've spoken to these landowners. I mean, I fought with them. I fought with them yesterday. I fought with them on Friday. I've offered to bring American truckers, and oftentimes under the H2 program, people will say, well, Americans don't want those jobs. That's why we have to give them to, other people from other countries. Well, in places like northern Maine, I mean, the logging industry is one of the few industries that there is, and the people that work there are incredibly hardworking. They're not slackers or anything like that. But I, after consistently telling people that, I can supply American, owner operators in areas that Canadians are hauling, they flat out refuse that. And I know you're going to hear, because this is what I've heard my entire life. These areas are so remote, Americans don't want to work there. You can be at St. Paul from my house in Allagash in an hour's time. There's no, with the road system that's in the North Maine Woods, I mean, there's really no place that is considered, that far or that remote. I mean, and if you're a logger and a trucker, you expect that you're going to have to travel, significant distances to make a living. So that's the bogus argument too that I expect you're going to hear. But it's just the fact of the matter that this is an industry that has used these workers to depress the rates, and I don't think there's anyone that when looked at can say that that's not actually happening.
Thank you, Senator Jackson. And I guess if there's no other questions, just as a follow-up to the issue around the video, if Legislative Council does take it up, I personally found the video very beneficial. I would encourage council members to allow sponsors at least to present videos or other presentations when they introduce bills. Maybe not everybody that speaks on a bill because they're limited to 3 minutes, but for sponsors, I think where there isn't not a limit of 3 minutes, it would be really helpful to allow that going forward if that does come up. So I guess
Mr. Chair?
Yeah, go ahead. Go ahead.
Could I have one clarification from the senator, please?
Sure.
So, Senator Jackson, so your stand is that because the trucking company is incorporated in the United States, the trucking part of it is legal, but because of the H2 visa, the employee part of it isn't?
My understanding is it doesn't matter where the truck is incorporated, if it's a Canadian owner, if it's a U.S. owner, it's the driver that violates cabotage. If it's a Canadian driver, then they can do point-to-point hauling. And it's the same way for Mainers going to Canada, New Brunswick, Quebec, whatever. We can haul wood into Canada, and we can go over there and pick up a load and come back. But we can't go over to Canada and pick up a load and deliver it in Canada. And the Canadians have no problems enforcing this. So it's basically the driver is the distinction. If it's a foreign driver, then you can't do point-to-point, in the United States, and same thing if it's a U.S. driver, can't do point-to-point in Canada.
But a U.S. driver could do point-to-point. I mean, a U.S. driver could, for a Canadian company, do point-to-point in Maine legally?
The U.S. driver could, yes.
Okay. Thank you.
But they don't hire U.S. drivers.
Oh, I understand. Yeah.
Any additional questions from members of the committee? Seeing none, thank you, Senator Jackson. I look forward to working with you on the bill at the work session. So we have additional testimony from those in support. Representative Martin, is he with us, Avery?
Checking attendee list now. All right, I'm gonna go ahead and promote him to panelist.
All right, there he is.
Representative Martin, welcome. Representative Martin, are you ready to present your testimony? Oh, there we are.
Representative Martin, you're still on mute.
No, we can't hear you, Representative Martin.
How about now?
Yep, there you go.
Perfect.
Okay, thank you. Let me just begin by saying to Senator Chipman and Representative Terry that I am John Martin and I represent District 151. If you think of the state of Maine beginning at Fort Kent and then coming down all the way down through Ashland and eventually getting to Oxbow, everything west of that highway, all the way to Canada is my legislative district. And obviously, along with the senator, I'm fully aware of what has been going on. And it has been an issue which we have tried very hard to talk to the industry about, but they seem to want to ignore it. Let me just first begin by saying that I am the sponsor and the creator of the tree growth law many years ago. And I did so in the belief that we ought to encourage people to, as much as possible, keep forest land in play, to grow trees for the use and the advantage for Maine people. And let me begin by saying this. I think that maybe what we need to look at is go back and take a look at, there are conditions upon which you have to meet in order to stay in tree growth. And those conditions are listed in the law. They include basically for a Granville forestry plan. They include a number of issues which need to be met, and every so many years that plan needs to be submitted, whether it's to the municipality or to the Maine Revenue Service. And maybe that we need to try to see if there's a way that we can incorporate that. The purpose is not to put harm on the people who deserve not to be harmed. But when people tell me that the landowners don't control who picks up the load, it's pure garbage. Because obviously the landowner or the person whom the landowner is hired to be the person who's going to cut and harvest the wood, either one of them will tell them where the wood is going and how it's going to get there and who not to hire. Very often they will say, we don't want that trucker. And there'll be an American trucker that they don't want to use because maybe they want to charge a little more than someone else might charge. So first of all, the landowners should never use that phrase with me anyway, because in the bottom end of it, they have total control of who's on their land and where that product is going. And they can dictate where the wood is going to go, and very often who the trucker is going to be that's going to get there. So I hope that the department does not take the assumption of the Department of Agriculture, Conservation, and Forestry takes this conclusion that the industry is being alarmed by what is trying to be done here. So I think that if the industry wanted to solve the problem, they could solve it real quickly. And I have been there. I represent the community of Portage, and I've seen it not once, but whenever I end up going to camp, I see it. And I meet the trucks on the highway, and I meet them on the Woods Road. And then all of a sudden I see them, and I have no problem when they come back, they come in to unload, but then all of a sudden I'll be in the yard and there they are loading the truck with a foreign driver, and they are frankly abusing the law. And if the landowners wanted to solve that problem, they could do so tomorrow morning. But they shy away because they're getting it cheaper by getting the people who might come in using a Canadian truck or a Canadian driver. And that's the reason they're doing it. But I think bottom line, this committee has an ability to deal with that issue. Tree growth was created for a purpose, and it created basically not only to grow trees, but to protect jobs and jobs in Maine. I've been through it, and I've seen it, and I think that what you've seen today is a good example of the abuse that's taking place. I'll be more than happy to respond to any questions today or any other time.
Thank you, Representative Martin. Is there any questions from members of the committee? Seeing none, thank you, Representative Martin, for being here with us. Appreciate
Thank you. My pleasure.
History on the tree growth law and your work on that over the years. So we have others that would like to speak in support. Dana Gardner. Is Dana Gardner with us?
Just promoted him to panelist. Okay, there he is.
Welcome, Dana Gardner. He doesn't seem to be with us, Avery. Well, maybe we should go to Dave Sullivan and come back to him.
Okay.
So we'll now hear from Dave Sullivan from Richmond.
Okay, Dave Sullivan is a panelist.
Great. Welcome, Dave Sullivan.
Side effects of unilateral ongoing.
Dave Sullivan, are you with us? Appears to be some kind of technical issue here, Avery.
I can go ahead and give them a call. I have their contact info and I can see if they're still on. In the meantime, do you want to try someone else?
Well, we don't have anybody else in support, so I'd like to hear from them before we move to those in opposition, but
Okay, sure. Let me try giving them a call real quick.
we'll take a momentary pause here and hopefully get things straightened out for both Dana Gardner and Dave Sullivan.
Hello.
Hello.
Can you hear me?
Yes, this is Dave Sullivan.
Yep. Hold on. I had to plug in another microphone here. So
Okay.
see if I can get it to work here. Okay. So if you can hear me, I guess I can go.
Yeah, go ahead, Dave, and then after you present, we'll hear from Dana Gardner. Will be next if we can reach with him. So go ahead, Dave.
Okay. Thank you, Senator Chipman, Representative Terry, and members of the committee. Again, my name is David Sullivan, lifelong Mainer here in Maine. I've been born and raised here, grown up here, and spent all my summers here trying to travel the state and get to know people in the state of Maine. I represent a lot of people in labor, about 6,000 members here in Maine, represent a lot of iconic industries such as logging, lobstering, shipbuilding at Bath, shipbuilding down at Portsmouth Naval Shipyard. So I get around the state and I get to talk to a lot of people. So I was calling in support of this bill because I think this bill is mostly about accountability. Senate President Jackson has put this bill in my opinion, after reading it, because we want accountability. And I think as Mainers, we want accountability. Maine government should want this accountability in my eyes. I think the landowners, they can't turn a blind eye to what's going on. They've been able to get away with it because nobody's pursued it. I spent time with Maine loggers up in the woods, looking at these trucks coming in, and the landowners have total control of what's going on. They have the power to direct these truck drivers. A Canadian doesn't get up in the morning and come to Maine and say, well, I'm going to go to Maine and deliver from all these points to points within the state of Maine. They're directed by somebody to do so. So I just think that it's hard for us as Mainers for us to turn a blind eye as well, because we know that the landowners have total control of this. And if a truck driver doesn't do what he's told, they'll find another truck driving company. So I think reading point-to-point legislation and trying to get into some of the conversations around this, and I read that the Canadians they can only deliver goods to and from the US. And then when I actually take a look and read the actual language, it seems very simple, very clear to me, that the actual language says that a driver may not pick up a shipment at one US location and deliver that shipment to another location. So it doesn't seem like there's a whole lot of gray area that the landowners can say that, oh, geez, we didn't know this was happening. So I just think that they need to stop, circumventing US workers. It's important to us, as labor, we supported this governor, and, and we want someone to look out for, the working men and women of Maine. And this is no slight for me. It's no slight at Canada, right? Canada is a great neighbor. Do a lot of stuff with Canada, but family's family, and Mainers are family, So I think that for me, just a regular citizen here in Maine, wanting to protect Mainers, that, we have to take a good look at this and just hold people accountable. This is about accountability. I've spent a lot of time in the Maine woods talking to Maine loggers and truck drivers. You'll hear from Dana. He's a truck driver. I've talked to him, but these are people that have invested their whole, life savings into their equipment, up in the Maine woods. I mean, there's not a lot up there. And if you haven't been, traveled up there or been in that part of the state, up in the Allagash, you'll see that, there's very few things that you can do to make a living that are, good for you and your family. So, we want these Mainers to be able to make a living and to have a good life, and, maybe to be able to go on vacation someday and take their kids to Disney or something, but not work, 15, 16 hours every single day because they can't make a living on what they're doing. So I certainly think that, when people invest in equipment, I know a lot of CDL drivers. It's a very important thing here for the state of Maine to keep CDL drivers in Maine. We use them in lobstering, logging, and shipbuilding. We have them in all the different industries, but we have to keep work available for them. So there is no shortage of them. Holding a CDL is a great honor for these people, and they have to abide by a lot of things on their personal time too. So they take it serious. They want to work. There's nobody out there that says they don't want to do this work. We have plenty of truck drivers that could do this work. So, I don't want to, pretend like it's, we have this labor shortage and we can't find truck drivers. They're there. They just need to be able to make a living. So I certainly hope that as lawmakers here in Maine that, we look at and take care of Maine workers, and there's nothing wrong with holding people accountable, whether they're landowners or the trucking companies. They all need to be held accountable. So, I just feel like, as labor and somebody that looks out for workers for my whole life and wanting people to make a living, I want to make sure that, Maine, legislature, our governor, right? Our governor, we were boots on the ground to get this governor elected. And we were the ones that were out going door to door saying men and women in Maine need a voice. And, we thought that she was going to be that voice. So, we fully expect the governor to support something like this and to make sure that these companies, these landowners, these Canadian truck drivers are all just held accountable. And that's all that we're looking for out of this. We're not looking to bash anybody, but just they need to be held accountable. And looking at the trip tickets and watching that video is a real eye opener on just how easy it is to hold them accountable, but nobody's been able to do that. So, I speak in support of this bill.
Great. Thank you, Mr. Sullivan. Other questions from members of the committee? Seeing none, thank you for being with us today. We'll now hear from Dana Gardner, who'd like to speak in support of this bill. Dana, you're muted. If you could just unmute your sound.
Dana, you're going to want to go to the bottom left corner of your screen. Just hover over if you don't see a menu, but you should be able to see a mute button. You can have the option to mute and unmute all the way over on the left.
Not yet.
Yeah, you're still muted, Dana.
Not yet. I think Avery's going to call to walk you through it. Here
I think
you
I
go.
just hit something that said unmute.
That's it. You're
You're
here.
all set.
All
Welcome.
right. Well, I can't hear you guys now, but
We can hear you.
Mercy sakes. Okay. My name is Dana Gardner. I've been a trucker for 25 years, and I've trucked in the North Maine woods, and I've seen this cabotage going on right from the first day I ever set foot in the North Maine woods. And it's becoming a real problem whenever it's taking food off your plate for your family. And you're trucking up to St. Paulfield with a load that don't pay enough as it is. And you could get a load paying your truck $1,000 or more to come back to Portage, but you can't get that load because Canadian trucks are doing it. And these Canadian trucks are not even bringing a load into US. They're coming in 4 or 5 times a day, loading American wood and bringing it wherever they want to. And nobody seems to be able to do anything about that. And I mean, I've got friends that would gladly come on this Zoom and tell you guys all about what's going on, but if they would say something, the landowner would blackball them and they'd be out of a job. And that's exactly what happened to me. Unfortunately, I've had some medical issues in the last couple of years that's preventing me from probably ever going back to drive a truck again. But friends of mine, relatives, brother-in-law, uncles, they've all been trying to get help with this issue. And the forest rangers, they don't care. Customs officers, well, it's not up to them. Border patrol, not up. No, yep, talk to somebody. I don't know. It's sad. And that it's a federal law and it can't be enforced. Like, I don't get it. Like, what's going on? But I mean, I was with Troy this summer and we took videos of the supposedly Reggie Transport created a G&H Trucking American company. So now it's an American truck. Well, their office is in St. Paulfield on the main side in a building that the grass is growing up around it. There's cobwebs. There's nobody in the door. There's no electricity in the place, but there's a sign on the porch says main office for G&H, and it's a Canadian phone number to call. So it's pretty black and white, you know. Really sad that we're losing out, you know, upwards to $4,000 and $5,000 a week gross revenue because we have to drive our trucks 100 miles back down a portage empty when we're following in the Canadians' dust, and they're getting it done and getting paid good money, not at a cut rate. They're getting paid good money to do it.
Mm-hmm. Great. Thank you, Dana. Is there any questions from members of the committee? Seeing none, thank you for being with us today. Appreciate it. So we now have heard from those that would signed up to speak in support. So we'll now switch over to those that would like to speak in opposition to LD 188. And Avery, just so you know, we'll start with those at the top of the list and work our way down. I think just to save some time as we promote people, we'll announce the first person and then say that the next person on deck, and then maybe you can promote them so they're ready to go right after the previous person. So we'll start with Anthony Horahan, followed by Ben Carlissi.
Okay, just promoted Anthony.
Good morning.
Welcome, Anthony.
Good morning, Senator Chipman, Representative Terry, and members of the committee. I represent Irving, timberland owner, mostly in Aroostook County. We've been timber owners in the county since 1946. We supply about a little over a dozen mills in the state of Maine, including two of our own, one in Dixfield and one in the Ashland area from those lands. And I'm here today to testify in opposition to LD 188. This is a bill that is presented to be a solution, but we don't believe that the problem lies with landowners. It seems that many folks think this is a legal issue that people that are using bonded labor have the right under the law to do so. So we think it's a bit of overkill. As Representative Martin spoke, the tree growth tax program was put in place in 1969 to promote landowners with more than 10 acres of forest land to keep these lands as working forests. The idea was to prevent good stewardship of the forests, benefit long-term Maine's forest industry, as well as to provide all the other benefits that society gets from healthy forests. The idea of removing a landowner from tree growth or using a legal contractor who is using a legal employee has nothing to do with good forest stewardship. The basis of qualifying for tree growth is based on having a managed plan and undertaking forest management, not managing an independent contractor's employees or a subcontractor's employees. Also, one of the issues we see with the bill is that tree growth today is the same for everybody from 10 acres to 1 million acres. And this would put different categories in place where someone with 50,000 acres or over would be treated someone differently than someone with less than 50,000 acres. If this is a big issue that needs to be dealt with, what's the difference in someone with 35,000 acres or 10,000 acres or 1,000 acres utilizing this if it's not a legal way to do business? The bonded labor that is undertaking the work is doing so legally under state and federal laws, is my understanding at this point. And Senator Jackson was pointed out that he's gone to many different departments and they've been initiated investigations and there was no violations revealed. So no violations, which tells me as a landowner that folks are working within the boundaries of the law. And in fact, that's ingrained in our contracts that they must follow all state and federal laws in our contracts. So again, it's a solution that's looking for a problem that I don't believe is tied to the landowner. And if there is an issue with the bonding, which is quite an intense process, to get a bond demonstrating that you can't find local labor, then that's where the issue should be looked at, but not on a tree growth tax that's there to promote good forest stewardship in the long term. So again, I'd urge you to pass, ought not to pass on LD 188. And I thank you for your time today.
Great, thank you, Mr. Horan. Is there questions from members of the committee? Yes, Representative Matlock.
Thank you, Senator Chipman, and welcome, Mr. Horan. I have a question about H-2A visas. I understand that's how the drivers are allowed to come into the country and go port to port. Who sponsors those H-2A visa applications? Does your company?
I'm not aware. We don't. No, we don't currently have any H-2A visas. I think the last time we did was probably 15 years ago or so. So it would be sponsored directly from the contractor, I would believe, but we're not directly involved in that. We
Okay,
tend to
because I was
we work
just looking
quite
at,
closely with H-2B on the silvicultural workers.
I'm sorry, say again. H-2B is the visas that your workers use?
Generally, that's the ones we use for our silviculture programs in the summer, our tree planters and folks like that. But our workforce is comprised of local Mainers from the county.
Okay. Thank you very much, sir.
Any additional questions to members of the committee? Go
I
ahead.
have one
Representative
quick
Farmer.
one, Mr. Speaker.
Sure.
Yes, does your company, do they harvest the wood and truck the wood? As a landowner, do you have all phases of this? Or are you?
No, no. So we're a bit of a combination compared to some other landowners. That the majority of our work is done with independent third-party contractors, trucking and harvesting included, as well as road building. We do have one small fleet of trucks that we run as company employees. So we do have that. That's a little bit of a, we call it the farm team, where we have folks that come on and we can teach people the correct way to drive and that type of thing. But generally, I would say 95% plus or 98% of what is done is independent third-party contractors.
And the people that you have doing them jobs, them are currently Maine citizens or?
Yes, they are. Yeah, we've made a big effort really since about 2004 to with training and trying to assist people through financing and other ways to get into the business. And as Dana pointed out a few minutes ago, having someone drive miles the wrong way every morning or something. So we're trying to find folks from the St. John Valley or the Oakfield, Holton area to work on our operations as contractors or employees.
Thank you.
Any additional questions from members of the committee? Seeing none, thank you, Mr. Horan. We'll now hear from Ben Carlisle, followed by Christopher Fife.
Good evening, good afternoon. Can everybody hear me?
Yes.
Okay, great. Thank you. It's Ben Carlisle, by the way. Distinguished members of the Joint Standing Committee on Taxation, my name is Ben Carlisle. I'm president of Prentice & Carlisle, headquartered in Bangor. We are a large forest manager and a forestry services provider. We represent forest landowners large and small in Maine and beyond, and we ourselves have owned timberland since our company's founding in 1924. And I'm here today to express my strong opposition to LD 188. As a landowner and land manager, we contract with many independent full-service logging companies to harvest and deliver our timber to various mills throughout the state. These third-party service providers are professional. They're excellent at what they do. They produce high-quality work, and they're diligent about following the regulations I operate under. Some of these service providers in turn subcontract with other vendors for part of this work, including for the transportation of these forest products. All of our contracts are conditioned on, among other things, these vendors following all applicable federal, state, and local laws. However, we can't police their daily activities or absolutely ensure that everything they do, both on and off our property, is legal. For example, deep in the woods, it's impossible to police who happens to be trucking the forest products on a given day, the routes they happen to use, the registration status of each of their trucks, the driver's immigration status, and instead we rely on the contractor's professionalism, much as any homeowner would do when they hire someone for work on their house. To punish a landowner for illegal activities of their contractors, as well as any subcontractors that are then hired by that contractor, is inappropriate and dangerous. It's akin to doubling a homeowner's taxes when a plumber is caught with an expired driver's license on the way home from the job. And much like the homeowner, landowners expect and demand through contracts that the people they hire follow the laws, and when they don't, we don't hire them. Canadian truckers can always refuse a point-to-point delivery if it would violate the law. We also object to this proposed legislation's perverse use of Maine's successful tree growth tax law as a punishment. When landowners are removed from tree growth, there's a significant tax penalty for withdrawal, and this penalty is an incentive to keep landowners in the program, to keep practicing good forest management for the long term, and not as a punitive mechanism when certain landowners are forcibly withdrawn from a program for totally unrelated violations of the law by third parties. LD 188 proposes that a substantial penalty and a massive tax increase be imposed on landowners, and I believe that will discourage keeping working forests working, and this is all for something they had no ability to enforce or control. The practice of point-to-point delivery by those who aren't federally permitted to do so is illegal, and it should be enforced. However, I don't believe LD 188 is the solution. It's inappropriately tied to tree growth and it imposes an astonishing punishment on landowners who have made no violations, and therefore I urge you to vote ought not to pass on LD 188.
Great, thank you, Mr. Carlisle. Is there any questions for members of the community? Go ahead, Representative Matlock.
Thank you, Senator, and welcome, Mr. Carlisle. Mr. Carlisle, does your company sponsor H-2A visas?
We do not.
Okay, thank you very much.
Representative Gramwood.
Thank you, Senator. Thank you, Mr. Carlisle. So I'm just kind of curious. I appreciate your perspective in terms of not being able to kind of have that kind of control in the northern Maine woods of who's doing what that you're not actually observing. But if you were aware of some sort of illegal activity, how would you address that?
Yeah, we there's certain
in
cases
terms of the point-to-point that.
Sure. Well, we aren't aware of if we were to discover that. I mean, the contractor would no longer work for us. There have been cases where we had to enforce laws where drivers have continually operated overweight, for example. And in those cases, when we find violations of the law, we no longer hire those people. So we have the ability to cancel the contract and to prevent them from being hired by us.
Thank you.
Any additional questions from members of the committee?
Yes, Mr. Chair.
Go ahead, Representative Carmichael. Go ahead.
Yes, Mr. Carlisle, when you contract a private contractor, do you have in writing any recourse for breaking the laws? Do you make it explicit in your contract with them?
We do. We have a statement in each of our vendor contracts that where they are directed to follow all state, local, and federal laws.
Thank you.
Any additional questions from members of the committee? Seeing none, thank you, Mr. Carlisle.
Thank you.
We'll now hear from Christopher Fife, followed by Don Tardy.
Good morning. Can you hear me?
Yes, go ahead.
Great, thank you. Good morning, Senator Chipman, Representative Terry, and distinguished members of the Tax Committee. Weyerhaeuser opposes LD 188. As we see this bill, it seeks to use the Maine tree growth tax law, tree growth, to penalize a subset of forest landowners in the state for actions taken by another independent business. And I want to mention that none of our land is actually in Aroostook County. We've really been drawn into this because of the arbitrary identification of 50,000 acres as a threshold for the size of landowner that would be potentially penalized for this with this new bill. Weyerhaeuser owns and sustainably manages over 840,000 acres of timberland in Maine. And our forest land is enrolled into the tree growth program. The trees that we grow and harvest make a significant contribution to Maine's forest economy each year. The forest products industry creates approximately 15,000 direct jobs in Maine, and each of these workers play an important role in the forest products supply chain. Forest landowners, logging and hauling contractors, and forest products manufacturers rely on each other. Tree growth provides a stable, consistent base for the industry, allowing landowners to maintain forest and make long-term investment in growing trees. This in turn supports outdoor recreation, clean air and water, and healthy wildlife habitat. LD 188 proposes to deal with trucking violations by removing a landowner from tree growth if an independent trucking contractor breaks a federal law or regulation or an international trade agreement. This penalty could be nearly $1 million. We hire independent contractors to harvest and haul our timber. Those contractors often hire independent truckers to haul the wood to the mills. Our contacts with these independent businesses require that all state and federal laws must be followed. We support full enforcement of all laws, including those regarding transportation of forest products by both state and federal agencies. But we rely on enforcement of laws to make these contracts meaningful. The equitable taxation provided through tree growth is an essential factor keeping Maine's working forest as forest. As you've heard, eligibility for tree growth must continue to be determined by current use of the land and sound forest management, and shouldn't be tied and allowed to become a tool of unrelated policy or issues. And finally, all wood harvested in Maine for commercial purposes is transported by truck, regardless of the size of the ownership. LD 188, as I mentioned, arbitrarily singles out forest landowners with more than 50,000 acres. The fact is that harvested forest products transported within Maine in violation, quote, in violation of federal law or regulation or an international trade agreement could as likely originate from a 20 or 100 acre ownership as one over 50,000 acres. So Weyerhaeuser respectfully urges you to maintain the integrity of the tree growth program by voting not to pass on LD 188. And I thank you for your time.
Great, thank you, Mr. Fife. Any questions from members of the committee? Representative Matlock.
Thank you, Senator. Mr. Fife, I'll ask you the same question I've asked the others. Do you sponsor H-2A visas?
We do not.
Thank you.
You're welcome.
Any additional questions from members of the committee? Seeing none, thank you, Mr. Fife. Appreciate your testimony. We'll now hear from Don Tardy, followed by Donald Mancius. Is Don Tardy ready to present testimony in opposition? Appears he's not ready or not with us for some reason. Is Donald Mancius able to come on and present testimony in opposition?
Can you hear me now? This is Don Tardy.
Yep, go ahead.
Okay, I'm sorry, I couldn't unmute on my screen. Honorable Senator Ben Chipman, Honorable Representative Maureen Terry, and distinguished members of the Committee on Taxation. My name is Don Tardy and I reside in Ashland. Today I'm offering testimony in opposition to LD 188. I've worked in the forest products industry since 1972. I've been a registered professional forester for all my forestry career. And I've held various forest management positions from manager of logging operations to woodlands, to lumber mills, fiber procurement for a major pulp and paper company. And I currently serve as president of the Ashland Area Economic Development Corporation. And this is the primary reason I'm here today. Because late in 2019, Ashland lost its major employer and biggest contributor to the municipal tax base. Reenergy's biomass electric generator contributed over $453,000 in annual municipal revenues, representing about 7 mills to the Ashland base. Prior to losing Reenergy, Ashland's mill rate was 27. In 2020, Ashland was able to bridge the 7 mill impact by exhausting its rainy day fund. The Board of Selectmen are desperately trying to find solutions to bridge the gap for 2021 with little success. The only real solution for our community is to encourage investors to come to Ashland. Our Economic Development Corporation is hard at work to obtain industrial property and market our community for the great forest resources we have around us. My primary concern with LD 188, if enacted, is that it has the potential to upset our whole ownership structure of the North Main Woods. Our forest landowners, loggers, and wood processing mills are the backbone of the Route 11 corridor in Aroostook County. Any upset situation resulting in changes to our three-legged economic stool will have a dire impact on our region. The resulting impact will also weigh heavily on our ability to attract investors to our region, as the sustainability of fiber supply will be seriously questioned. My second concern with LD 188 is, since the inception of tree growth tax law in 1969, it has been the favorite punching bag for many who have an axe to grind with the forest products industry. Tree growth is the most progressive forest taxation law in the country. Many states I've had the good fortune to work in envy Maine's tree growth tax law. We can attribute Maine's current forest inventory and solid base of private landowners, small and large, to tree growth. It has served our state extremely well for over 50 years. So why do we have to change it now? My final concern is that bonded and visa labor has been within the fabric of Maine's woods labor force since I can remember. Today, the numbers diminished to a handful from the great numbers that were needed to salvage the timber resulting from bedwar infestation in the 60s and 70s. Through the history of the Canadian Labor Program, there has been complaints on a number of occasions without significant findings. If there are significant abuses, let's have the federal government investigate our own program or its own program so we can deal with facts rather than anecdotal comments. Why should we risk the whole economic infrastructure of our forests without facts? Our own State Department of Labor has conducted their own investigation without findings. Are we destined to continue chasing ghosts on the program, or should we get the facts and act accordingly? I respectfully ask you to support our forest industry and vote ought not to pass on LD 188.
Great, thank you, Mr. Tardy. Are there any questions from members of the committee? Seeing none, appreciate you being with us today. We'll now hear from Donald Mancius, followed by Hannah Stevens. And for those that are presenting testimony today, please know that you'll need to start your video if you're going to present to us with video, and also unmute yourself for the audio. Is Donald Mancius with us?
Senator, I am speaking neither for nor against today, so I can wait my turn.
Yeah, okay. Well, we had you down as speaking and against. I'm not sure why that is, but we'll come back to you when we get to neither for nor against. Appreciate you.
Thank you, sir.
So is Hannah Stevens with us to speak in opposition to this bill?
Yes, I am.
Welcome.
Hi, thank you. Let me just get my screen here. Senator Chipman, Representative Terry, and distinguished members of the Taxation Committee. I am Hannah Stevens, a resident of Glenburn and Land Use Director of Seven Islands Land Company. I'm speaking in opposition to LD 188. Seven Islands Land Company manages approximately 820,000 acres of family-owned commercial timberland in Maine, the majority of which is enrolled in tree growth. And I want to point out that in 1973, parcels of timberland over 500 acres in size were automatically enrolled in the program per law, whose purpose is to serve the public interest by encouraging forest landowners to retain and improve their holdings of forest lands, and to promote better forest management by appropriate tax measures in order to protect the unique economic and recreational resource. It's been successful in achieving this goal and is still an important component of forest conservation in the state. It's arguably one of the most successful in the country and will be increasingly important in the future as the state and nation look to forests as a natural climate change solution. According to the bill's proposed language, in the event of a violation of federal transportation laws by companies or individuals that transport forest products, this bill seeks to penalize large landowners with a mandatory withdrawal from the tree growth tax program. Most companies that do the work of transporting forest products are independent contractors and not employees of the landowner or land manager. As such, the only source of influence or recourse the landowner or land manager has is through our contracts with the independent contractors. And like others, our contracts are explicit in the requirement that federal and state laws must be followed, including those dealing with bonded labor, such as those under the H-2A worker program. Under this program, it is legal for a Canadian driver to pick up a load of logs in Maine and deliver it elsewhere in Maine. Hence, why would drivers endeavor to undergo the rigorous process to obtain H-2A visas rather than operate as a B-1 driver where point-to-point deliveries in the US are prohibited? The financial penalties incurred by landowners in a mandatory withdrawal from the program, as is contemplated by this bill, would constitute a consequence far in excess of the violation. Further, such egregious use of the tax policy to enforce a labor-related matter represents a very poor precedent and a jeopardization of the stability and benefit of this program that this program has provided to the state. There are already existing procedures in place to deal with violations of federal or state labor laws, making this bill unnecessary at best and at worst, a short-sighted, harmful, and unprotected attempt to once again link the tree growth tax law to an unrelated and non-existent issue. Therefore, I urge you to vote ought not to pass on LD 188. Thank you for your consideration.
Great, thank you, Ms. Stevens. Are there questions from members of the committee? Representative Matlock.
Thank you, Senator. Ms. Stevens, I note that you do have folks, you do sponsor H-2A visas with your company?
We do not. We contract with a contractor who does have H-2A drivers under their employment. What we do is provide a letter to the contractor that this is how much we'll be hauling so that they can petition to get those workers.
So it's a contractor to provide visas? Or is it a trucking company?
It's a trucking company, correct. And they have to go through the process of, proving that there aren't all the requirements of the H-2A program, proving that they cannot find American workers, et cetera, in order to hire H-2A drivers.
Okay. So this is a trucking company and the trucking company doesn't own any forest lands or anything like that?
Correct. We're not a trucking company. We're a land management company. We manage for the landowner.
Thank you very much.
Great. Any additional questions from members of the committee? Seeing none, we will now, thank you very much for your testimony, Ms. Stevens, appreciate it. We'll now hear from John Cashwell, followed by Patrick Stotch. Mr. Cashwell, are you ready to present testimony in opposition?
I'm working the mute button here. I'm John Cashwell. I'm the a representative of BBC Land LLC, which is a management company that manages 1 million acres from Machias River to the New Hampshire border. I'm not involved in the North Maine woods at this time, though I used to be in 2 different positions. One is the director of the Maine Forest Service, which oversees timberland all over the state. And the other was as president of Seven Islands that I ended work with in 2008, I believe. While I don't have the total details of the senator's video and that sort of thing, I do want to object to this law because of the tree growth tax, being used inappropriately and heavy-handedly to enforce state and/or federal laws related to transportation H2A and whatnot. It's sort of, it's a funny thing. I live in Bangor, Maine. You have a grocery store nearby that receives all kinds of goods and services via truck drivers, and it would be like, you being responsible for the driving behavior of the beer truck that comes every other day and delivers stuff to your store. And if they have 3 violations, then it would be like taking the liquor license away from that store and raising their taxes in arrears for about 3 years. It doesn't match up with the legal and structural system that we have in this state. I would urge you to not to pass this bill because it's I believe, an inappropriate use of tree growth tax to enforce laws, ancillary laws in the business of moving, producing, and delivering forest products. It doesn't match up. Thank you.
Thank you, Mr. Cashwell. Any questions from members of the committee? Seeing none, appreciate you being here with us today. We'll now hear from Patrick Stotch, followed by Peter Prandafilo. Is is Patrick Stotch with us?
Yes. I think you can hear me.
Yes,
Senator Chipman and Representative Terry and distinguished members of the committee. My name is Patrick Struck. I'm the Executive Director of the Maine Forest Product Council. We try to make sense out of all the different memberships that we represent. We have loggers and truckers, as well as pulp mills and paper mills and sawmills, and over 8.5 million acres of dues-paying landowner members as well. So I work hard to try and arrive at the many issues we get confronted with. We have generally been working on rebuilding our economy and recovering from the pandemic and making great progress that way. But this issue is a passionate issue by the senator. He and I have been at our positions for the similar amount of time. This is actually a generational issue, talking about Canadian labor in the Maine woods. And so we've been dealing with this for some time. This bill we're against. It has a lot of things that are disproportionate in terms of structure and concern. It penalizes folks in the tree growth tax program. I think you've heard from the landowner community, who incidentally is not the villain here. They've been working hard with their contractors through this pandemic to keep everybody whole and to try and find a way to work up in this North Maine woods region that we seem to be talking about. Landowners haven't talked about this much, but they have kept operations going. They've had temporary shutdowns, but it's remarkable that they've been able to work in the region, and I think all of those involved are appreciative of that. The tree growth penalty, you've heard a number of reasons why we're against that. It's not connected directly to the issue. It discriminates against an entire class of landowners. When you start separating tax policy into size classes of landowners, you begin to violate some principles of taxation. You need to understand there's a penalty when you get out of the tree growth tax law. And that's a significant penalty. It's designed that way. Never mind the new tax rate you're taxed at. So these are not little numbers. They're disproportionate. They're outsized with any kind of penalty we're aware of for federal violations of cabotage laws. But we can talk about that some more, but that's why this is such a huge disruption in the workforce. Cabotage law, I can help you, not in 3 minutes, but We can talk about the visa categories that are involved in this. The B1 visa is what is the Canadian coming across on a daily basis and hauling into Maine. And those are the folks that are under the cabotage laws. The H-2A visas that we've been talking about, they are, it's a program managed by the state of Maine for the federal government. So you have state officials watching over that program. And at this point, you might think there are thousands of truckers coming in under this program. Right now, there are 12. We're talking about 12 truckers who, in combination with US truckers and contractors, are hauling materials within the state of Maine. They go through a rigorous process, and just like you can apply for these H-2A workers to be truckers, you can apply for them to be loggers and mechanics. There's also programs associated with the H-2A and H-2B that bring in restaurant workers. So it's a similar kind of way. We have to make sure, and there's a vigorous program to bond these agents to make sure they're not disrupting a US job, and actually they can get bumped by a US worker within 6 months of their initial appointment. So it's a pretty rigorous appointment process. These are not cheap ways to go in terms of bringing people in. You need to be, contractors need to be really working thoroughly to try and bring these folks in. So I just wanted to provide that kind of perspective. You've heard about landowner control. I think you understand they're not hiding from anything. They run top-notch businesses. They want all their contractors to obey the law. This is not a loophole situation. This is something that everybody is working under the law. We've worked with the congressional delegation to understand these concerns. We work closely with the Maine DOL. There was actually an investigation last year, complaint raised. The Rangers were out taking a look at the complaint, and they came back with no violations based on the dual citizenship of those that were involved. So there's a lot more to this. I understand it's a passionate issue for the senator from Aroostook, but there's a lot more to be discussed and some perspective to be shed on this issue. And I think there's plenty of questions you can ask of a number of people that are involved in it. So I thank you for your time, and be glad to answer any questions that you have.
Thank you, Mr. Strach. Is there any questions from members of the committee? Seeing none, appreciate you being here with us today. We'll now hear from Peter Trandaflo, followed by Tom Doak. Is Peter with us?
Good morning. Can you hear me?
Yes, go ahead.
All right, great. Great job on my name, by the way. Peter T to most folks. Thank you very much for having me. Distinguished members of the Taxation Committee, my name is Peter Trandaflo. I live in Orono, and I represent Huber Resources Corp. It's a family-owned timber management firm that manages approximately 600,000 acres here in Maine, from northern Maine to down east Maine. I'm going to be respectful of your time because we are running kind of late. And I'll start by saying I concur with what the previous opponents have said, and I will concentrate on 3 particular points that I'd like you to think about, and then hopefully come in under 3 minutes. As you've heard, tree growth is a very long-term commitment. It's arguably the most successful and cost-effective conservation program in the state of Maine. It's prevented thousands of acres from being developed. But as you've heard, there are penalties for being withdrawn. Now, nobody's ever pulled out 50,000 or 100,000 acres out of tree growth, so I have no idea how the penalty would be calculated, but they're assessed on a per acre basis. And they're based on the difference in valuation between the value of growing trees for tree growth or ad valorem. And even if the difference were only a couple of dollars per acre, for a 50,000 acre landowner, you're talking about $100,000. For 100,000, you're in 6 figures before you know what's happening. And generally speaking, the valuation difference between tree growth and ad valorem is quite a bit more than just a couple of dollars per acre. So the penalties are just way outsized of anything that would relate to transportation law from what I can see. I just can't see a reasonable person considering it equitable. I want to reiterate the point that the loggers and truckers that work on Huber's, on the land that Huber manages, are professional, independent contractors. They're not our employees. Folks have said that the landowners direct everything and they're in control of all of this trucking. We do in fact have contracts to deliver wood to mills, say Irving's mill in Portage, or the mill in Masardis and Ashland. And so we ask our contractors to deliver wood to those locations. However, we don't get into the employment of our contractors. That's their business. We don't control who their drivers are and where their drivers are coming from. We just ask them to harvest wood in a certain manner based on a management plan and deliver it to certain mills based on the contracts that we have. So the idea that we're somehow in the pockets of all of these contractors and directing them in every aspect of their business is just not true. We just ask them to do a certain service, and how they run their business is up to them. As with previous speakers, all of our contracts have clauses that require contractors to meet all applicable laws and regulations. Our remedy, if they don't, if there are violations, is to terminate a contract and not contract with them again. However, that's an after the fact event. We have to see evidence of a violation, and then we can terminate the contract. And under this law, we would already potentially be on the hook for these outsized fines. I want to point out again too that this is a federal issue about its international transportation and international drivers. I believe it's regulated under USMCA, the successor to NAFTA. And as previous people have mentioned, it's been audited before and violations haven't been found. So I just don't see where there's, I don't see the problem, and I certainly don't see the need for potentially threatening landowners with such huge fines. And the very last thing I want to say is that, and somebody already said it, is there is a class of foreign labor, like the H-2As, I believe, where it's legal for them to go point to point. So some people don't believe that that's true, but in fact, that's the reason why no violations have been found. And as Patrick said before me, those people that run those trucks, there's about 12 of them in the state of Maine. That's it. I would urge you to vote against this. I'm opposed to it, and I would be happy to answer any questions.
Any questions from members of the committee? So if you were aware of a violation, what would you do about it?
I mean, we try to be fair. If a contractor violates something like they have overweight trucks, we'll point it out to them and say, you've got to stop doing that. If they have if they continue to do so, then we would just terminate the contract. We stop doing business with it. We have every right to terminate a contract, regardless of how far along we are in a job, if the contractor is not obeying the laws of the state of Maine or the federal government. So that's our sole remedy, is to cease doing business with them.
Right, I understand that, but if you're getting a substantial tax break under tree growth from the state of Maine, do you think there's some obligation to report violations to the proper authorities if you're aware of them?
We depend on the authorities to tell us of violations. We're not an enforcement agency. We could be opening ourselves. I would think we could be opening ourselves up to legal consequences if we accuse contractors of breaking the law. So if they broke cabotage laws and we were informed that the Department of Labor or the federal government was fining them for violating laws, then we would exercise our right to terminate the contract.
No, I understand that, but if you were aware of violations that were going on and nothing was done by state or federal authorities about it, because maybe they didn't know, there's no investigation, but you were aware of it, in addition to terminating the contract, don't you feel like you have some kind of obligation to report those violations, since you are getting a substantial tax break from the state of Maine to being in tree growth? Is there some obligation on your part to report any violations like that, in addition to
that's a good question, Senator Chipman. I really can't answer it. The only time we've exercised that clause was for overweight trucks. Some truckers have difficulty staying within that rule. And if we see more than a few, we give them warning, and that's a fairly clear thing. It's weight. It's pretty obvious whether they're obeying or not, versus labor laws and cabotage, which most of us don't understand. So the only one we've ever done is overweight trucks, and we didn't turn them in to the police because by that time it's only our record and the trucks are gone. We just stopped doing business with them.
We have questions from Representative Matlack, I believe was first, followed by Representative Sachs.
Thank you. I'm concerned. You don't know enough about cabotage to worry about it?
I expect the contractors that we hire to obey all the laws. They're the experts because they're using the program. That's not my field of expertise. We manage timberlands.
Okay, with the contracts with your truckers, do you specifically point out cabotage? Because that has been something that's been of concern recently. So they just provide trucks and you don't make any requirements that they be allowed to go between facilities within the state of Maine?
Our contracts specify that they have to obey all laws and regulations. We don't itemize them out. They have to obey all laws and regulations.
Okay, thank you.
Representative Sachs.
Thank you very much, Mr. Chair. So, Mr. T, I would ask a sort of complementary question to that my colleague did. We've just heard repeatedly that landowners are stating that we require in our contracts that they follow all state and federal laws. However, you don't have any enforcement whatsoever that you just stated. You would only find that out through a Department of Labor, Federal Department of Labor. You don't check trip tickets or anything like that we were brought evidence of?
We see them all, and if something looks fishy, we'll go after it. We just never had that situation. Let me put myself in the position of a contractor that's doing work with my company. If my company, if I'm accused of breaking the law, I'm gonna say, well, prove it. You know, I mean, you're not the police and you're not the law enforcement agency. So,
well,
you
that
know,
was my question regarding your trip tickets. So I'm assuming you issue trip tickets that your contractor, and do you review them?
Of course we do, yes.
Yes.
And
So
like I
that
said,
would be the
some-
proof. That would be the evidence. And you're saying you've never seen evidence of that. But if you
Sabotage?
did, you wouldn't wait for a Department of Labor, that you would go ahead and enforce that.
I am not sure how we would handle that, quite frankly. That's never happened. And we're very careful about not being enforcing agents. We can terminate a contract, we can stop doing business with somebody, but we're not enforcing agents.
I guess I would have some concerns only because we've heard that repeatedly, that you should not penalize us because we have this clause within our contract that states you must follow them. However, we do nothing, to your point, to actually determine that. You're just resting, and then you just said, well, then have them prove it. You have the means to do that through these trip tickets.
The trip ticket doesn't say whether a particular driver is an H2A or a B1. I have no way of knowing that from the trip ticket. The Maine Forest Service, if they're auditing, can go further, but I just have the trip ticket. It shows where the wood came from, where it went, who the trucker was, but whether that trucker has got the appropriate, the contractor is the one who makes sure that they have the appropriate, and the legal trip tickets that we have don't list that information, not that I've ever seen.
Thank you for your answers.
Any
Trying to do my best.
Any additional questions from members of the committee? Seeing none, thank you for being with us.
Thank you for having me.
We'll now hear from Tom Doak in opposition, and then we will move to testimony from those neither for nor against, starting with Donald Mancius. So we'll now hear from Tom Doak.
Great, thank you. I hope you can hear me. Chair Chipman, Chair Terry, members of the committee, my name is Tom Doak. I'm the Executive Director of the Maine Woodland Owners. We're the organization that represents the smaller woodland owners in the state. Generally, those own 10 acres up to maybe a few thousand acres. The tree growth tax, and speaking in opposition, the tree growth tax law is really the most important tax law for our family woodland owners in Maine. It is the reason that so many landowners are able to keep their land as forested land. The purpose of the program is to keep land and tax land as forest land instead of its development value. There are about 10,000 smaller owners in the program. As it was mentioned, initially everybody over 500 acres was put into the program, whether you wanted to be or not, you were put in. Most of the time a landowner, as it's currently written, obviously most of our the people that we work with would be exempt, the 50,000 acre limit. But the biggest fear that a woodland owner in that we represent has about being in the tree growth tax law program is a change that occurs that they are that after they've enrolled. And to understand that it is, you know the rules when you get in. Those are understood. But the legislature can change the rules anytime it wants. And there is no, unlike most tax programs, there's no out for free. Under the Maine Constitution, you must pay a penalty if your land comes out for regardless of what reason. So landowners are very nervous about those changes that occur. So you have a situation here in this bill where you're bringing something into the Tree Tax Law program that is completely unrelated. Transportation is not talked about in the law at all. And so you're bringing something in, and then as we interpret it, you're holding the landowner or penalizing a landowner for the violation by someone who's doing something else on their land, not their violation, but the actions of somebody else. Those are the kind of things that really scare the smaller owners and make them kind of fear this program. We think there should be a lot more people in this program. We think it's a great program. It has done more to conserve woodland than anything else in the state of Maine. But that fear of those changes and being stuck and then penalized, either removed, kicked out for something, or having to get out and pay a huge penalty, because the penalties are purposely very high. They're kept very high, often much more than you would have saved if you were that you've saved by being in the program. So those are our objections. If there are laws being broken about the transportation of wood, we have no problem enforcing them, but we think this is the wrong mechanism. And I would say, I think this has a 3-strike, as written, it has a 3-strike provision. I would hope after the first strike that whoever collects that information gives it to the appropriate people to enforce the law. With that, I urge you to oppose this bill.
Thank you, Mr. Doak. I just have a question. What is the size of the small woodlot owner to be a member of the organization? What's the sort of maximum on that for a small woodlot owner?
We don't really set the number, but it would be, the maximum size would generally be a few thousand acres, something like that. And,
if we're talking, I believe with this, we're talking about 50,000 acres or more, so this wouldn't really apply to small woodlot owners, right?
As I mentioned, as written, it doesn't. Our concern is you're bringing the idea of bringing something unrelated into the program, and then that concept of now holding somebody, a landowner responsible for something that is unrelated or not of their actions as part of the Tree Tax Law program. That's our concern.
Okay. Representative Matlock.
Thank you, sir. Mr. Doak, thank you for being here. A quick question. You said you hoped that whoever found that the folks doing the trucking of the forest products that were in violation would be reported to the appropriate authority. Do you know who the appropriate authority is on this matter?
I don't. I assume it's the Department of Labor. I'm assuming it's either the state or federal Department of Labor.
Okay, thank you.
Any additional questions to members of the committee? Seeing none, thank you for being with us, Mr. Doak. Appreciate it. So that concludes all the testimony from those in opposition. We're now going to move to those neither for nor against, starting with Donald Mancius, followed by Jay Wadley. Is Donald Mancius with us?
Yes. Thank you, Senator Chipman, Representative Terry, members of the committee. My name is Donald Mancius. I'm Director of Forest Policy and Management for the Maine Forest Service, speaking on behalf of the Department of Agriculture, Conservation, and Forestry, neither for nor against the bill. We understand it's been a challenging time for the forest products industry. The pandemic, mill closures, the explosion of the Jay Mill in particular, have all posed unprecedented market challenges for the industry. In response, the administration and our staff in the department have been working collaboratively with stakeholders, including the federal delegation, on many of these important issues. For example, last fall, Commissioner Beal wrote a letter to the USDA secretary asking the USDA to add loggers and truckers to the coronavirus food assistance program. And we were pleased when the last COVID-19 relief package included $200 million for loggers and truckers. I'm just going to tighten up my testimony a little bit since a lot of the points have already been made. We are most concerned with the language concerning the tree growth tax law. As it's been stated repeatedly, the tree growth tax law was created to support and promote long-term forest management through the appropriate valuation of working forest land. and the program stability has been central to its success over the last 4+ decades. We don't see the nexus between taxation of forest land and the hauling of forest products. As others have pointed out, truckers are independent contractors. Landowners really do not control what those truckers do. We also have concerns about the principle of equal treatment regarding the application to landowners who own more than 50,000 acres. Should the committee choose to move forward with some version of this bill, we are okay with section 1, which can be incorporated into the regular activities of Maine's forest rangers. I do want to note that based on what I've heard the proponents present this morning, we'd like to have the chief forest ranger at the work session to answer questions about trip tickets and anything to do with law enforcement matters. Thank you for your time and consideration. Happy to answer questions now or at work session.
Great, thank you, Mr. Mancias. Is there questions from members of the committee? Representative Matlock?
Yes, thank you. Thank you, Mr. Mancias. In follow-up to something Mr. Doak said, who is the enforcement authority with regard to whether or not truckers can transit between locations within the state of Maine?
Like Mr. Doak, I'm going to take a guess that it's the Department of Labor. The Maine Forest Service is not the law enforcement arm for labor laws.
What are they the enforcement arm for?
We enforce the state's forest practices laws, timber trespass, fire safety regulations, things like that.
Okay. And what would section 1 add to the amendments that Senator Jackson proposes in section 1? What would they add to the enforcement authority of the wardens? Right now, the existing law allows forest rangers to obtain copies of trip tickets from the truck drivers. This would add the owners or managers of log mills and log yards, so that basically it allows them to go to the mill or the log yard and ask for the trip tickets, as opposed to just asking the trucker. Okay, thank you very much.
Representative Terry.
Thank you, Mr. Chair, and thank you, Mr. Mancias. Would you, since you are returning and the Forestry Service is coming to the work session, could you check in with the DOL to see if they are, in fact, the proper enforcement, I guess?
Yes.
Or, you're welcome to invite them to attend with you. We'll happily listen to them as well.
Thank you.
Thank you.
Any additional questions to members of the committee? Seeing none, thank you, Mr. Mancias. Appreciate you being with us today. So that concludes, so now we're in neither for nor against. We've got 2 more speakers. We'll now hear from Jay Wadley, followed by Melinda Bouchard.
Not quite good afternoon, we're getting close, but my name's Jay Wadley, Senator Chapman, Representative Terry, members of the committee. Thank you for your time. I'm a former member of the Maine Citizen Trade Policy Commission, and I represented workers on that board. Canada does a real good job of protecting its workers. We could spend a lot of time talking about the rules they have and how they protect them, but they do a good job. And we have rules that prohibit point to point. I know that's been a bit of a discussion among the landowners who said H2A is okay. If they're correct and H2A is okay, then they shouldn't have to worry about any violations coming from that. Because the penalties only happen, the way I read it, if there's a violation of law. So if what they're doing is legal, then they have nothing to worry about. But it seems that the federal government's reluctant to expend the resources on enforcement. Maybe they don't have them. I know it's been kicked around from different who does enforce it. Everybody from ICE to Department of Labor. But if we want fair trade and we want to protect Maine workers, we need to take some action. If you can't count on the federal government to do it, we got to do something ourselves as a state. 30 years ago, landowners like Great Northern, IP, and Irving, they all had employees, thousands of employees. They wanted to change those over to be independent contractors. And when they did that, they got to shed their health care, they got to shed their pensions, they got to shed all of that. But we can't let them shed responsibilities for law violations. So if they're still ultimately responsible for laws being violated on their behalf, be it they're independent contractors or not, We need to do something about it. And there is the 3-strike rule in there. So if, like Mr. Carlisle said, and a couple of the other ones, if they see a violation and they fire the guy, how many contractors out there are going to continue to violate if they know the result is they'll be fired? So number one, there actually has to be a violation. And if H2A isn't, then there's nothing to worry about. Number two, if they do take care of their people and they fire them, they'll never get to a third violation. So I'm in favor of anything that promotes fair trade, and that's what I'm looking for here. This bill may do it. It may need to be more severe. Maybe the penalty should be longer. So that's why I'm speaking neither for nor against, but we do have to do something to promote fair trade between the Canadians and ourselves.
Great, thank you, Mr. Wadley. Is there questions from members of the committee? I don't see any. Thank you for being with us today. Appreciate your testimony. We'll now hear from Melinda Boucher from Fort Kent.
Yeah, Boucher. Do you guys hear me?
Yep, we can hear you. Go ahead.
Okay. Senator Chipman, Representative Terry, and distinguished members of the Taxation Committee, it has come to my attention that there is another bill, LD 188, this session targeting H2A employees and employers utilizing this program. I am an H2A processing agent for Northridge Services, doing business as Lalou Company in Fort Kent, and for 8 years now have been working hand in hand with these employers to ensure all federal and state regulations are followed. The H2A process is without a doubt not an easy process for these employers. It is time sensitive and quite an intense process with no guarantee for these employers that they will be getting an I-94 DHS arrival department record issued to aliens who are admitted to the US by USCIS for the employees they need. There are at this time 9 employers utilizing the H2A program, requesting 95 workers, in which not all positions are occupied. These companies are located in northern Aroostook County to western Somerset County. Employers utilizing this program are in remote locations where laborers are simply not close to the work sites or just don't want to work based on the job requirements. The employers are obligated to hire US American workers under all federal regulations. Please note, all employers would hire skilled American workers, but are simply unable to find them despite following all federal requirement regulations. The H2A process is a federally regulated program overseen by the US Department of Labor. Not only do employers have to follow federal regulations, but also have state regulations to abide by. That being said, this program is heavily regulated by USDOL and the Maine Department of Labor. Employers undergoing federal audits almost every year and enforcement of state regulations daily. There are no state nor federal laws violated by these employers. There has been inaccurate misinformation targeting the H2A program, which results in stress on these H2A employers. Please note these employers are following all federal and state regulations, are doing above and beyond what is required of them in order to obtain these certifications. If you have any questions, I'd be happy to answer them. And if you need any information, I'd be pleased to send it. Thank you for your consideration.
Thank you, Ms. Boucher. Question from Representative Matlock, followed by Representative Terry.
Thank you, Senator, and welcome, Ms. Boucher, to our meeting. You can answer my questions about H2As.
Yes, I was waiting for my turn.
Great. So you say there are 95. Is that a number set by the federal government as to how many H2As are available? I'm wondering if it's like the employment of summer workers for local restaurants.
Yes, no, the H2A program is not like the H2B program. The H2B program is what they refer to as a cap program. They are only allowing a certain amount of H2Bs into US. The H2A program is not, it does not have a max or a min. It does not have yeah.
Okay. So how do employers need to prove that they cannot get American workers to do the job at American wages, or how do we ensure that American workers aren't being shut out because they cannot accept a low wage like a Canadian worker may or driver may in order to do the job? What is the responsibility of the employer?
Yes, you hit two good points, which I'd also like to hit on. The wages is one thing we have to abide by with regulations of the federal regulations. We have to abide by state prevailing wages in order to hire these U.S. workers. And the state prevailing wages is pretty much a minimum per job title that you will be doing. So if you do hire a log truck driver, we cannot be giving a U.S. less money than a Canadian or vice versa, I'm going to say. So yes, that would be number one on wages. Number two would be the requirement of the regulations based on the recruitment of U.S. workers. So if you are under the H-2A program and you are requesting these H-2A workers, you have to, by federal regulations, provide proof that you have done, obviously abide by the regulations, which are 3 journal advertisements. In which they tell you where you have to advertise. So we have to advertise in the state of Maine. We have no choice but to advertise through the Bangor Daily News. We cannot do any local advertisement through a little community journal. Has to be through Bangor Daily. And then we have to do through New Hampshire and Vermont advertisements. It has to be on a large circulative day. So it has to be on a Friday to a Saturday advertisement. So we hold a Friday advertisement in the Bangor Daily, and we also hold a Saturday/Sunday because there's no newspaper on Sunday. They combine them. So we do 2 advertisements in Bangor Daily, and we do 1 on Friday for New Hampshire and Vermont.
Okay. Thank you very much. It's been very informative. Will you be back on for our work session?
I was not planning to, but if you guys need me to, I will most definitely be there for you guys.
Thank you so much.
Representative Terry.
Thank you very much, Mr. Chair, and thank you, Ms. Boucher. I appreciate you being here and definitely answered a lot of questions. The 95 visas that are currently out there, correct?
Yes. Yes.
Are they in different industries or just essentially just in this industry?
No, and I also, that's a good question. I also want to mention too, although I've only been doing this for 8 years now, processing for these H-2As, I also have background in the wood industry. I also broker wood. So yes, I know a lot of the like all the other parties were stating, trip tickets, the wood industry. I'm very involved in that as well. So that's a great asset. But as well, I also know a lot of the history of the H-2As. And I will tell you that a lot of people have stated that, the forest industry is not agricultural, but however, it has been agricultural as an H-2A for the last 11 to 12 years now. There has been controversy about why we are linked into that program. And that's up to the federal U.S. Department of Labor to make that decision. So they have linked us into an H-2A because it is agricultural and these are seasonal workers. So they cannot be seasonal requirements are no more than 10 months of the year.
Okay, so they're partially in the wood industry, but they're also partially in picking regular seasonal agriculture picking or harvesting, that is.
Yeah, so the employers that I mentioned that utilize these H-2As, which I think I cover them all. So I can tell you personally that they are all under logging. These classifications entail a feller buncher operator, a processor operator, a grapple skidder operator, a truck driver, a crane. Everything that's associated in the logging industry is underneath this H-2A program.
Okay. And then just to follow up on your advertisement for jobs for American workers. So what you're saying is that someone in, say, northern Aroostook County has to get the Bangor Daily News in order to find one of these jobs?
Yes, that's a requirement of the advertisement part, but we also are required by the Department of Labor regulations to go on the main career site. So anyone that is filing unemployment actually has that linkage through the Department of Labor's career sites to find these jobs.
Yeah, and nothing local though. There's no local advertisement for these jobs.
Nothing local, only because the U.S. Department of Labor requires the largest circulation, and it's tough because like I might have one employer in Northern Aroostook, but I might have another employer, you know, in the Western Somerset. So the local advertisements, the Department of Labor requires us to do the largest circulation to kind of hit all areas of Maine based on the fact that I know a lot of people have said that they're not remote areas, but if you look at the map, they are considered remote areas where there is no grocery store. You know, so it's very hard to find the employees that want to go into these work sites. I'm trying to not steer my decision on the bill, just trying to give you guys educational information to make your decision.
Of course, I understand. Okay, thank you so much.
You're very welcome.
Yep.
So I'm just wondering, Ms. Boucher, maybe you can help me understand the disconnect, because I know there's a high unemployment rate in Aroostook County. It's higher than almost any other area of the state. There's people looking for work. We've heard testimony that there's people that haul wood that are looking for work. Where's the disconnect? How come you're not able to locate those people and hire them as opposed to hiring people from?
Yep. And I'm going to take my my experience in the wood industry now, not as the H2A processing, to give you my information or my knowledge. It's not just the H2A employers that are having difficulty finding these employees. It's the industry as a whole. And I hate to say it, but these are not, I know the wood industry is a very unique industry. And if you do not understand it, it's very, it's not challenging to understand, but there's just a lot to it. So all I'm gonna say is my personal opinion is that these are skilled, and I hate to use that word, but it's truly the honest, my honest opinion. There's skilled workers. You know, you cannot, myself, if I were to apply for this feller buncher position, you know, I'm a US worker. I have, you know, all the knowledge of the forest industry and the wood industry. However, I have zero experience running a feller buncher operator, to be a feller buncher operator. These pieces of equipment are expensive. They are not just, you know, jump in a car and drive. You know, if you have a license, it's something that takes time to learn. And a feller buncher operator, the requirements for an H2A is 6 months experience. So just as long as a US worker, if applies for the job, proves this knowledge, you know, we have applications that they fill out. So if they show that they have 6 months experience, then they automatically have to get hired by US Department of Labor's rules and regulations. So.
Any other questions from members of the committee?
Yes, Mr. Chair.
Let's go ahead, Representative Carmichael.
Mr. Boucher, do you have a sense that this is a program that can be easily abused by contractors?
Sorry, what was that, Representative?
While there's been a lot of suggestion and testimony today that this may be a program that can be easily abused by contractors. And do you have a sense about whether that's something that can easily happen? Is something we should look, well, the proper.
So this is very hard of me to answer without siding on one side or another, but I'm just here to give you guys the knowledge of the programs. And I'm going to say that without a doubt, it's extremely tough to not follow the rules because, like I said, we have the Department of Labor who initially regulates this program. Pretty much at me weekly, daily, you know, asking for proof of this. You know, there's so much that goes into this program. It's not just, you know, oh, here's my I-94. It's not that. It's so much more. You know, these U.S. companies have to provide proof that the taxes have been paid on this equipment, that the company is a U.S. company, that, you know, and I could keep you here and tell you all the regulations. So to say that this is happening, I'm going to stand here and tell you that I honestly do not think this is happening because we would be notified. These H-2A employers would be calling me saying, hey, you know, we have an issue, this has happened, such and such. And knock on wood, we've been very lucky with the audits, the federal audits, and we have been very fortunate with our Department of Labor to provide them the documentation that they need to undergo the regulation of the program.
Thank you. Very enlightening. Thank you very much.
You're welcome.
Great, thank you. Is there any additional questions from members of the committee? Seeing none, thank you, Ms. Boucher, for your testimony today. And I believe we have one more person that would like to speak, Mr. Delisandro, who didn't get signed up on our list for some reason, but Mr. Delisandro, would you like to offer testimony either for or against?
Yes, I would. Thank you. Senator Chipman, Representative Terry, members of the Taxation Committee, good afternoon. My name is Daniel D'Alessandro, and I'm an attorney for the Office of Tax Policy from Maine Revenue Services. I'm here today at the request of the administration to testify not for or against LD 188. The bill has several issues that are unclear and make it not administratable as currently written. In addition, we are unable to determine the fiscal impact or administrative costs without further clarification, but they could be significant. As the Senate President said, we have met with the sponsor and raised our concerns and appreciate the steps that the sponsor has taken to address those concerns. We await amendment language and would appreciate the opportunity to make further comment at that time. The administration looks forward to working with the committee on the bill, and representatives from MRS will be here for the work session to provide additional information. I'd be happy to respond to any questions you may have now.
Are there any questions for Mr. Delisandro from members of the committee? Yes, Representative Carmichael.
Yes, thank you, Mr. Chair. Mr. Delisandro, I can't pronounce your last name, I apologize. I do have a question. Is part of the administration's concern with this the enforcement mechanism that the sponsors have chosen to put into the bill?
So as written, the enforcement mechanism is a little unclear. We have a violation by the truck driver, then linked to the landowner, then linked to tax penalties, and then further linked to other state funds and other credits. And so there are details that are missing in that process that make it difficult to envision how it would be administered at this point. But the Senate President did speak to changes to the bill to address some of those concerns. So I think I'd like to wait to see that amended language to really get into that.
Thank you.
Any additional questions from members of the committee? Seeing none, thank you for being with us, Mr. Delisandro. Appreciate it.
Thank you.
So that concludes the testimony on LD 188. We'll now close the work session on this bill, and we will move right into the public hearing on this bill, and we'll move right into the public hearing on LD 179 that's sponsored by Representative Kessler, who's here to introduce that bill for us today. Representative Kessler with us? Oh, there he is. Welcome.
Good afternoon. Can everybody hear me okay?
Yep.
Ron. Welcome.
Hello, everybody. Good to see you all. Let me get myself queued up here. I just want to say I appreciate getting to you guys at your hungriest hour. So I hope you were able to get my testimony before the committee hearing, and feel free to read along if you wish. But Senator Chipman, Representative Terry, and members of the Joint Standing Committee on Taxation, I am Representative Chris Kessler, and I represent District 32, part of South Portland and part of Cape Elizabeth. I also serve on the Energy Utilities and Technology Committee, and I am an energy auditor by my profession. And today I am proud to be before you to present LD 179, an act to exclude energy efficiency improvements from property tax. I believe that it is of utmost importance for this committee to consider for what purpose we use our constitutional authority to levy taxes. Tax policy can be a tool to encourage economic activity that achieves good outcomes for our communities. We may afford developers tax credits to set up a business in our community in order to create jobs, or we afford low-income households tax credits to give them economic security. When such tax policy is successful, it benefits the entire state. Last session, this committee and the legislature passed LD 1430, an act to create tax equity among renewable energy investments. That legislation was introduced because property tax policy was in direct opposition to the state's renewable energy goals. There was inconsistency in how municipalities assessed solar for property tax purposes. And in some municipalities, the tax assessed was an impediment to development. In all cases, it was viewed as an unfair penalty. Unfortunately, that same problem still exists today for investments in energy efficiency, particularly with ductless heat pumps. And I just have to note that this bill was really spawned by my own personal experience when I was looking at how much my home was assessed for and had then discovered this situation. So because an outdoor unit for a ductless heat pump is attached to the building, some municipalities have decided to assess a tax on the heat pump as an additional feature. Values for heat pumps vary across communities if it's included in the valuation at all. In South Portland, an average of $4,600 value is placed on a single zone installation. Our homes and businesses have been converting to heat pumps to lower their heating bills and get off fossil fuels, and the city has thus far assessed over 400 heat pumps. The total assessed value of ductless heat pumps in South Portland is currently around $2,180,000. If you are looking at my testimony, I provided an example of what this costs the average homeowner. So if our mill rate in South Portland, it's $19.75 per $1,000, that means each home that has just one heat pump pays an additional $90.85 in property taxes. It may be more if they have a larger unit. This begs many questions for me, though. For example, a person might invest in a heat pump for the same reason they might convert to natural gas and install a Rinnai heater to lower their heating costs and improve comfort in the winter. Or they may have a central AC system, and that may be installed to improve comfort in the summer. The ductless heat pump is assessed a tax as an additional feature, whereas the other two systems are not. How is this equitable treatment? Should HVAC equipment be taxed simply because it's more efficient? What does this look like to a low-income household that finally was able to invest in efficiency for their home? For simplicity, I provided an apples-to-apples comparison of the cost of heating a small home with an oil boiler versus a ductless heat pump, assuming a 100% conversion. So 100% of the heating load is covered. The cost of heating comparisons and installation costs themselves are taken from Efficiency Maine's website. And you'll see with oil at $1.80 a gallon, as it has been over the fall, compared to electricity at 17 cents a kilowatt hour, that homeowner would save approximately $171 per year. If you look further down on the small table there, the equipment cost is $37.50. Efficiency Maine offers low-income rebates for heat pumps at $2,000, so the net install cost is $17.50. However, their savings is cut in half through this assessed tax. So the property tax assessed on the ductless heat pump doubles the payback period for the homeowner well beyond the equipment's life expectancy, which is about 15 years. The intent is to install a heat pump, or the intent to install a heat pump was to save energy and thus save money. And it's important to note that the cost of oil will fluctuate wildly, and so savings will vary from year to year, but it begs the question, is this fair tax policy? It's important to note that 5 other states exempt energy efficiency improvements: Arizona, Maryland, Nevada, New York, and Virginia. And New York's exemption has been in place since 1977. I provided a link in the testimony too, so you can see where that is referenced from. As the Honorable Ryan Tipping stated in his testimony last year, exempting solar from property taxes supports the reinvestment of energy dollars into the local economy. The same applies in this case. Although we might not be dealing with the many thousands of dollars of taxes that was imposed on a single solar array, that $90 is someone saves could otherwise be spent on their electric bill, a local restaurant, or a few Christmas presents under the tree. Every little bit helps. As a policy of our state, we should be doing everything we can to encourage investment in energy efficiency. This bill is a starting point to address the inconsistency in how efficiency is valued. This committee, the legislature, and the governor all agreed that our tax policy should match our climate goals with the passage of LD 1430. This committee should pass LD 179 this session for the same reason. Thank you very much for listening, and I'll be glad to answer any questions that I can.
Thank you, Representative Kessler. Are there any questions from members of the committee? Representative Matlock.
Thank you, Mr. Chair. Good afternoon, Representative Kessler.
Good afternoon.
A quick question for you. Is this an inconsistency with assessment? Because I believe that was one of the big problems we had last year with the legislation, was the inconsistency between assessors and municipalities deciding whether and when to assess a value to solar arrays. Is this also an inconsistency with assessors across municipalities, between municipalities, to determine whether or not to assess, or how to determine at what point you do?
Absolutely. There's great inconsistency across municipalities, from, including that as just what you view as the heating system, to varying values. Like, for example, $4,600 is certainly not how much I paid for the installation of my heat pump. And so it will vary from house to house in South Portland, and different municipalities will vary on the value.
Can I ask another question? With regard to air conditioning units, are they generally internal, or do they have external pieces, and that's it's taxable because you can see it?
Yeah, so if you are looking at a central air conditioning system, yes, there will be a condenser unit on the outside of the house, so you can certainly see that. And when the house is given its assessment, that is one of the factors that plays into the overall value of the home. But it's certainly not added on as an extra feature like a ductless heat pump is.
Thank you very much.
Representative Krasik.
Thank you, Mr. Chair. Representative Kessler, I'm assuming that these new taxes are being put on to these heat pumps when they go in to apply for their plumbing permit to do the new installation. I'm not guessing that there's a assessor going to everybody's house to see if they have one in their backyard or not. Is that what's happening in your district?
I can't say for certain the exact method in which they identify them, but that is certainly one way, or also upon the sale of the property.
Okay, and there's no depreciation involved. So once they assess this on your property, that value is going to stay on your for the value of your home forever, even though 10, 15 years from now, if it was any other kind of equipment where you could depreciate, that value is going to stay even if it's 10, 15 years old. Is that correct?
I can't answer that with certainty, but I can say that there are certainly older heat pumps that I have identified in South Portland on that home's value that has not changed over time. So, yeah.
Okay, thank you.
Any additional questions from members of the committee?
Energy questions, anything?
Seeing none, thank you for being with us today, and sorry for the long wait. I know you've been waiting for a while. Appreciate it. I don't think there's anybody else signed up to speak in support of the bill, but we do have folks that want to speak in opposition to the bill, starting with Brenda Cummings, followed by Kate Dufour. Brenda Cummings with us?
Yeah, she's up. Ms. Cummings.
I think I've got it.
Oh, there we go.
Go ahead. Welcome, Ms. Cummings.
Hi, thanks. Just give me just a second. I didn't know you were coming to me so quickly. So I want to modify I prepared a written statement that I will submit. I'll modify it slightly as I go through this. Thank you very much, Senator Chipman and Representative Terry and members of the Taxation Committee for allowing me to testify today about LD 179. My name is Brenda Cummings and I'm the assessor for the city of Bath, Maine, as well as a resident of Bath, Maine. I'm testifying today personally as a representative of my profession, not on behalf of the city of Bath. And I'm speaking against LD 179, an act to exclude energy efficiency improvements from property tax. I want to start out by saying I am personally, should I turn on my camera? I don't know why I don't have a video. Let me just check to see if I can turn that on.
Video, you might have to do that on your end.
Hang on.
Yeah,
there you go. Now you can see me. Hi. I'm personally a very strong supporter of energy efficiency and conservation measures. My parents' house has solar panels, and my father, Bob Cummings, wrote a book on building energy efficient houses, which he passed out to constituents in his district when he ran for the state senate in the 1980s. I regularly go to the library book sale every year to collect copies so I can give them away to somebody else. However, LD 179 as written would dramatically change assessment practices and increase costs significantly and undermine basic property assessment principles. Let me explain why. So there are a lot of misconceptions of what assessors do in what the sponsor has described to you. Appraisers and assessors both value real property. We're both seeking to identify a market value, what the Maine Constitution calls the just value of a property. Appraisers value one property at a time. Assessors value all of the property in our jurisdictions at once. The simplified version of how we do that is to say we look at the characteristics of properties that have sold, establishing the market indicated value of various styles of buildings, their conditions, the quality of their kitchens and bathrooms, the age of the property, and any other factor that appears to impact the valuation of a home. We then generalize from those sales to all of the properties in our jurisdictions, quantifying, estimating the value added or subtracted by various property characteristics. And we estimate the value of the properties that haven't sold by applying those values that we've created from the properties that have sold to all of the properties. So one problem with LD 179 is that assessors don't collect the details of personal appliance choices when collecting data on property sales. And indeed, we wouldn't have any source of such information. We don't detail brands or energy efficiency ratings for appliances or energy efficiency measures in every resident's home. We have in Bath maybe 70 to 120 market sales each year, and we value about 3,800 real estate parcels. We have limited existing data that would indicate how market value of a property might change due to the installation of any particular energy efficiency improvement. outside of limited information on the valuation impact of various types of heating systems. So the example that you used about the heat pump is probably one of the few things we could actually put some kind of number to. But in general, we have no source of data to apply to implementing this bill. The real estate market in Maine doesn't describe the energy efficiency ratings of the properties for sale. There's no source for market data to determine the correct exemption amounts to be applied. And figuring out the valuation impact would be statistically really difficult to establish because there's too much detail, too many distinctions between each type and specific installation of energy improvements. So one of you talked about the $90 value in South Portland or the $90 tax amount in South Portland for a heat pump. Well, South Portland may have been able to distinguish the value of a heat pump and have set it at whatever they've set it at, and Bath might be able to extract the value of what a heat pump might add to the overall value of a house. But our job is to value the overall value of a house and the land. It's not the assigning of a number to that item is a mechanism to get to the big number. It's not definitive in and of itself. And in terms of what the value is of that heat pump, it's an estimating process. Let me give you an example. Let's talk about fireplaces. Most assessment systems count the number of fireplaces in a home and add value to a property based on the number of fireplaces. The amount of value a fireplace adds to a particular property might vary depending on the style or the condition of the house, whether it's in good condition, poor condition. The value added will likely vary based on whether the fireplace is a traditional fireplace or it's fueled by gas or electricity. We establish those amounts and how they might vary by looking at property sales in our communities. The valuation changes created in Bath by a fireplace addition might not be the same as the valuation changes that a fireplace creates in Brunswick or Phippsburg. It's going to depend on the market forces in our towns. But it would be extremely difficult to quantify the valuation differences between one brand of electric fireplace or another, or the difference between the valuation between one with a 2-foot opening versus a 3-foot opening.
And Ms. Cummings, could you give us a final thought? We do try to ask people to stick to 3 minutes if we could, and we're well over that now.
Really? Wow, sorry. I think it's important for the legislature to consider the larger picture of property taxation. We are required to implement Article 9, Section 8, which states all of the Constitution, which states all taxes on real and personal estate shall be apportioned and assessed equally according to the just value thereof. All property tax exemptions break that promise because they require all the taxpayers to pay incrementally more to provide the exemption, because the exemption creates a smaller tax base. Unless the legislature fully reimburses that exemption, you are penalizing communities that might want to create a program to support energy efficiency by making their tax bills go up. I applaud the legislature's interest in promoting energy efficiency, but there are other methods of providing tax breaks and incentives for energy efficiency that spread the impact of those tax breaks more fairly, like creating the income tax or sales tax exemption for energy efficiency improvements. Those would be much, much easier to quantify and implement than a property tax exemption.
Great.
I urge you to rewrite the bill.
Great, thank you, Ms. Cummings. Are there any questions from members of the committee? Representative Terry.
Thank you, Mr. Chair. Thank you, Ms. Cummings. Quick question. How long has the city of Bath been assessing heat pumps?
We had no, since we did a revaluation in 2019, and I'm not even sure that it's one of several methods of heating that I could choose in my valuation choices.
Okay, thank you.
So it's not, I don't count a heat pump and have a dollar amount applied to it.
Okay, thank you.
Representative Kreisler.
Thank you, Mr. Chair. Just a quick question. So what I'm understanding is if you doing a reevaluation in the town like we did in Acton several years ago, that my neighbor has an old boiler and I've got a heat pump, the value of my property is more because I have the modern technology. Is that what I'm understanding?
I don't know. It would depend on your community. So it depends on the market in your community.
Okay. If we had,
Is your property worth more? I mean, if you had the exact same house, would your property be worth more?
I'm saying if we have, because you're taxing the heat pump. So if
But
I have.
I'm not taxing the heat pump. I'm taxing the property.
Right.
So the question is, what is the property worth?
Okay, so if I have more technology than the house next door, then my property would be valued more.
It might be, but it would depend on all of the characteristics of your property.
Okay, so if the houses were
It's
selling.
just one factor among many.
Okay, so if the houses were selling pretty much the same in my neighborhood, having a heat pump is not going to increase the value of my sale.
It should not.
Okay, that's what I wanted. Thank you.
Additional questions, Representative Gramlich.
Thank you, Senator. Thank you, Ms. Cummings, for coming. So just based on what I'm hearing, correct me if my conclusion is inaccurate. It sounds like there's a great deal of inconsistency amongst assessors and amongst municipalities in terms of whether or not one would include the additional home efficiency equipment like a heat pump or not, and to what degree they would include that as part of the valuation. Is that or am I in the ballpark with that assessment, with that assumption?
No, I think you're misunderstanding the premise again. We are all seeking to value the property according to its just value and apportioned equitably thereof, right? Just what it says in the Constitution, the property as a whole. To get to that number, we're going to determine locally what the right factors are. It's just a mechanism for getting to what the value is as a whole. It's not, it looks like you're taxing this one thing, but you're not. It's just a piece that goes into the whole value. So if you were to appeal your valuation, if Representative Kessler were to go to his local Board of Property Tax Review and say, you have valued this heat pump too high, what the board should tell you is, that's nice that you feel that way, but what you need to prove in order to prove your case, you have to prove that the total value that I have assessed your property for is not the right value. Whether your heat pump is at $90 or $200 or $2,000 doesn't matter if the answer is the right answer for the total house, for the total property.
I appreciate that. The right answer sounds, in my opinion, a little bit subjective, but we can tease this out in the work session. Thank you very much.
It's assessment.
Additional questions from members of the committee? Seeing none, thank you for being here, Ms. Cummings, appreciate it. And next we will hear from Kate DeFore to speak in opposition, followed by Dr. Allen for neither for nor against. Welcome, Kate.
Good afternoon, everyone. Senator Chipman, Representative Terry, and members of the Taxation Committee. My name is Kate DeFore, and I'm here on behalf of the Maine Municipal Association to provide testimony in opposition to LD 179. And I think you'll find that my testimony is remedial in comparison to the testimony you just heard. But I want to focus on two policy concerns. And the first is with respect to using the property tax as a means for funding, incentivizing state priorities. Municipal officials across the state believe that energy efficiency improvements are absolutely important, but the objection here is a turn to the property tax rather than state revenues to fund these incentives. So we established this principle of our priorities, state priorities, are more important than local priorities when you take value away, when you when you take value away that's not available to fund a local priority, you're sending a message that state priorities are far more important. So there's that policy concern that is troubling. There's another element of the bill that's a bit more troubling, which has to do with assigning this authority to decide what is exempt and what isn't to a quasi-organization. So if you take a look at the bill, it basically says that the Efficiency Maine Trust is directed to create a list of all exempt properties, qualifying exempt properties, and to inform the municipalities of this responsibility. From our perspective, we don't think that that's good public policy, because if a third party suddenly gets to decide on its own what is and isn't taxable, we miss out. We miss out on a conversation that we're having today, discussing why these exemptions do or don't work. And we also could miss out on the constitutional requirement that you reimburse municipalities for 50% of that loss. So I urge you to really look at that closely, that I think there is an abdication of tax policy when you allow another party to decide what is taxable and what is not. And I thank you for your time and consideration, and will answer any questions you might have.
Great. Thank you, Ms. Dufour. Any questions from members of the committee? Seeing none, thank you for being here. It's great to see you again. I don't think we've seen you yet since we started up this year. So
thank you.
So that concludes, actually, we're going to now take testimony from those neither for nor against. That concludes our testimony from those in opposition. For neither for nor against, we have Dr. Allen who'd like to speak to the committee. Is Dr. Allen with us? Welcome, Dr. Allen.
Good afternoon. Senator Chipman, Representative Terry, and members of the Taxation Committee. My name is Michael Allen. I'm the Associate Commissioner for Tax Policy in the Department of Administrative Services, and I'm here today at the request of the administration to testify neither for nor against LD 179. The bill would require assessors to determine the value added to a property by the eligible energy efficiency improvements. These determinations would be new in kind and scope and administratively challenging. They would require a significant amount of additional work for municipal assessors and Maine Revenue Services. In addition, this exemption may have a significant impact on taxpayers by restricting revenue sources for municipalities and in a manner effectively increasing the property tax on residents who cannot afford to add energy efficiency improvements to their properties. The administration feels that consideration should be given to the effect this bill would have on further erosion of the property tax base. On a more technical note, the bill leaves open significant issues in the definition of qualified improvements. While a preliminary fiscal estimate is not available at this time, an exemption of this potential magnitude may affect a significant portion of Maine residents and may result in a substantial annual reimbursement by the state to municipalities through the requirements in the Maine Constitution. In addition, this bill would also place a significant additional workload on municipal assessors, requiring a 90% mandate reimbursement for administrative expenses through the requirement in the Maine Constitution. The preliminary administrative cost of the bill is estimated to be $190,000 to $210,000 to fund 2 new property appraiser positions at Maine Revenue Services to administer the exemption. If it is the desire of the committee to support this legislation, Maine Revenue Services would like the opportunity to work with the committee to consider a number of changes in order to improve the long-term administration of the program. The administration looks forward to working with the committee on the bill. Representatives from MRS will be here for the work session to provide additional information and respond in detail to the committee's questions. Be happy to answer any questions you may have now.
Thank you, Dr. Allen. Is there any questions from members of the committee? Seeing none, thank you for being here. Thank you for being with us today. I don't believe there's anybody else that wants to speak neither for nor against. We will now close the public hearing on LD 179. We will now move to the public hearing for LD 198. At this time, I'm going to pass things over to Representative Terry, since I'm the sponsor of this bill.
Sounds terrific.
Thank you, Senator Chipman. And why don't we hear from Senator Chipman on LD 198?
Great. Good afternoon, Representative Terry and colleagues on the Joint Standing Committee on Taxation. As you know, I'm Senator Ben Chipman. I'm here today to present LD 198. This is an act to improve Maine's tax laws by providing a property tax exemption for central labor councils. If you're we're on this committee last session, you'll know this is a bill that we heard last year, and I believe we passed, but it went to the appropriations table and died along with many other bills when we abruptly adjourned because of the pandemic. So just to refresh your memory, this bill seeks to address a parity issue. As it stands now, chambers of commerce, fraternal organizations, and boards of trade receive a property tax exemption. Central labor councils, however, do not. Central labor councils are important civic-minded institutions in their communities. For example, the Eastern Maine Labor Council in Brewer provides a variety of important social services to the community, including running a program to deliver Thanksgiving meals to workers laid off from their jobs. This bill provides a real property tax exemption for real estate and personal property owned and occupied or used solely for their own purposes by central labor councils. I believe that if organizations advocating for the business community, such as chambers of commerce, can receive the property tax exemption, then labor councils formed by workers deserve the same benefit. In closing, I thank you for your time and attention today. I know we've been running kind of late. Happy to answer any questions now or at the work session. Thank you.
Representative Kryzak.
Thank you, Madam Chair. Senator Chipman, do you remember what the vote was the last time?
You know, I don't. I'm not sure if it was unanimous. I believe there was some Republican support, if not unanimous, but I actually don't recall. Maybe someone else on the committee would, or we can find out from Julie. There was strong support. I just don't know if it was unanimous or not. I don't remember.
Okay, thank you.
I would be willing to bet that our next participant might have the answer to that. Any other questions for Senator Chipman? Seeing none. Up next is in favor of the bill, Adam Good with the Maine AFL-CIO. Welcome.
Good afternoon, Representative Terry and Senator Chipman and members of the committee. My name is Adam Good, Legislative and Political Director with the Maine AFL-CIO. We represent 40,000 working people in the state of Maine, work to improve the lives and working conditions of all working people, and testify in support of this bill. I apologize, Representative Kryzak, is that the right way to pronounce?
Yes.
I believe last session, Representative Bickford voted for this bill. Can't speak for him right now, but I think that he continues to be supportive of it, at least in concept. And all the Democrats voted for the bill in committee.
Thank you.
It has $1,600 fiscal note. And you know, I don't want to take up a ton of your time. I recognize that I should have some type of tribute to give the committee, which I hope that you are keeping a list of IOUs and would love to be added to that list to provide some type of tribute in the future. Right now, you can just see my living room. Central labor councils play a very important role in improving the lives of working families. In Maine, there are 4 central labor councils. One of them, the Eastern Maine Labor Council, has a physical structure and thus currently pays property tax. Leaders of the Eastern Maine Labor Council are able to share about the services they provide. I know at least Jack McKay is planning to testify. They provide many services to the community in Eastern Maine out of the Solidarity Center located in Brewer. These include a solidarity harvest where they distribute up to 1,400 Thanksgiving baskets, enough to feed over 10,000 people. They do that every November. It's a giant program that helps, mitigate hunger issues and help working families. They have a greenhouse which annually provides seedlings to over 350 families in Bangor and Brewer. They have lots of partnerships with faith communities. They do an annual legislative breakfast that many members from the area have attended. They run a hotline to support workers to help gain voice and fairness at work. And just fundamentally, we see this as a parity issue. Chambers of commerce, boards of trade, fraternal organizations, they all enjoy a property tax exemption. Passing LD 198 would just add central labor councils to that list of organizations receiving the property tax exemption. And we just think that it's an organization that provides an appropriate balance to the chambers of commerce or other business organizations that currently enjoy a property tax exemption. We think it's only fair that central labor bodies be added to that list. Yeah, I don't have a lot else. That is a very small fiscal note. I know that MMA is on this Zoom meeting. I suspect will testify in some aspect, but the services that the Solidarity Center and the Labor Council provides the community are broad and helpful, and I don't think that they fit anywhere outside of the political spectrum, or any of the activities are any different than what chambers of commerce do, what boards of trade do, what fraternal organizations do. So it feels like a very small bill, and I'm happy to take a stab at any questions.
Does anyone have any questions for Mr. Good? Seeing none, thank you very much. Next up is Jack McKay from Brewer, and following that will be Jeff McCabe from the MSEA.
Great, thank you. Good afternoon, Senator Chipman, Representative Terry, and members of the Joint Standing Committee on Taxation. I'm president of the Eastern Maine Labor Council, and I have been for nearly 20 years, which has 34 affiliated unions representing over 5,000 workers in Eastern Maine. Our mission is to improve the lives and working conditions of our members and all working people in our region. On behalf of the Eastern Maine Labor Council, I wish to testify in support of LD 198. LD 198 would rectify gross inequity. Central Labor Councils play a similar role as chambers of commerce, and as such help level the playing field between workers and management so that we can have a vibrant, equitable economy with shared benefits for all. However, the playing field is seldom fair, and Maine's property tax exemption tilts that playing field in favor of management through property tax exemptions. Currently, chambers of commerce and boards of prey are exempt from property taxes, while central labor councils are required to pay. And I think, there's no frightening door that might be opened on this. Central labor councils are very resource poor. None of us has paid staff. Our property taxes, which are just under $3,000, constitute about 10% of our total revenue. We certainly don't mind paying our taxes, but then chambers of commerce should do as well. Or if they don't have to, then we shouldn't have to. And as Adam said earlier, we do a number of programs to support the community. In addition to the Thanksgiving baskets, which we raise roughly $60,000 that in turn goes to local food producers to provide Thanksgiving meals to people in our community, as well as throughout the state of Maine, which is gifted. We have a greenhouse on the side of our building, which provides seedlings to over 350 families throughout Bangor and Brewer at low-income housing facilities, and this is all gifted and volunteer run. We also do a number of educational programs. We have a legislative forum, which we're very happy has both Republicans and Democrats attending for over 15 years. And we see LD 198 as basic fairness, and we're very much in support of it. I'll be happy to ask any questions about the Eastern Maine Labor Council or other central labor councils for that matter.
Anyone have any questions for Mr. McKay? Seeing none, thank you very much for your testimony. Appreciate it.
Thank you.
Excellent. Next up is Jeff McCabe of the MSEA.
Good afternoon, folks. Senator Chipman, Representative Terry, members of the Committee on Taxation. I am Jeff McCabe, and I serve as the Director of Legislation and Politics for the Maine Service Employees Association, Local 1989. It's great to be here with the committee today. We are a labor union representing over 13,000 workers and retirees statewide. We are here today in strong support of LD 198. You probably also received some testimony at some point in time from one of our board members who is a DOT worker and very active with the Labor Council, and had hoped to be here today, but it is a season where they are plowing, and I imagine he had a busy night last night. So here sort of pinch hitting, but also happy to share some stories. You've heard a little bit about one of the Labor Councils and such a unique opportunity that the Labor Council provides, and really making a difference statewide and across the region, no doubt. My trips to the building that houses the Eastern Maine Labor Council have been for education, social gatherings, and events addressing food insecurity issues. Every time I've been there to an event at that location on the banks of the Penobscot River, I have seen young people and older folks all pitching in to make things happen and to support the community. I've talked with staff, interns, volunteers, and others. Several years ago, I drove to the Labor Council building just before Thanksgiving, and I loaded my SUV with food. Picture for a moment, if you will, turkeys, potatoes, cranberry, baked goods made by the community college system, and so much more. All the seats down in my SUV and just room in that SUV for the passenger and driver. We drove that food to Machias to meet workers who had been laid off when the Down East Correctional Facility had closed the previous winter. Driving up there that day, we knew that we had homes for some of the meals. We had, after all, called the workers and families. Each time we described the Solidarity Harvest Program, we talked with folks and said union members and others are helping workers, not with charity, but with solidarity. We hope they'd understand. We arrived, we set up a folding table in the parking lot in Machias, just outside Helens, and we sat there waiting for a short period of time. We were reunited with many of the laid off workers that some of you here today in the committee had met. We were met with hugs, tears, and we distributed a couple dozen Thanksgiving baskets that day. I think in these current times, it's so important that we think about ways to return events for social gatherings and for information. So with that in mind, I am also recalling several legislative breakfasts held at Eastern Maine Labor Council and visiting with former colleagues, including a former colleague of many of us, and including myself, the Honorable Richard Campbell. He felt it was always important to attend the Labor Council breakfast, and he looked forward to it each year. And I just remember several times standing in the back of the room with him or outside in the parking lot as we talk with folks about that event and about the important programs that occur here. Last fall, my son asked my wife and I when we were planning to go to Brewer to volunteer to sort food for the Solidarity Harvest, something we've done as a family several times before. I had thought, originally we probably wouldn't go because of COVID. And then I quickly learned that it was something that we could do as a family, socially distanced, outside, and being safe. It was a real special moment for us, considering the last year has just been so disruptive for my 12 and 15-year-old. And we went and we spent a morning up there packing Solidarity Harvest baskets. It was really a great opportunity, and it provided my children an opportunity to engage and have some level of normalcy. When you get my written testimony today, you'll see just sort of how big that effort was. This year was the 18th annual Solidarity Harvest, and that was something that provided over 1,400 Thanksgiving meals. I've always been struck with the overlap of these programs, not only with labor, but other community groups, faith groups, and so many more who've stepped up to help laid off workers. And this year, especially during a time when so many folks were laid off due to the pandemic. I'm happy to answer any questions, and I look forward to seeing this committee again in the future.
Thank you very much, Mr. McCabe. Does anyone have any questions? Seeing none, thank you very much for your time. Anybody, doesn't look like we have anybody else in favor of. We have next up Kate Dufour from MMA as an opponent.
Representative Terry and members of the Taxation Committee. My name is Kate Dufour, and I'm here on behalf of the Maine Municipal Association to oppose LD 198. Want to say we do agree with the proponents of the bill that it's important that all types of organizations are treated fairly. We certainly agree with Mr. McKay with respect to maybe we need to reevaluate who is exempt in the state, because if you look at the growing ranks, it seems that particularly in some communities, the value of the exempt property is outpacing that of taxable property. And you need just look to your service center communities and your poorer service center communities like Lewiston. So there is an issue here where we have a system that requires municipal government services to be funded primarily with property tax dollars. Yet there are influences that dwindle those property tax dollars that are available. And so we think it might be time, rather than having these perpetual discussions about who is worth or who's not worth an exemption, because as you heard today, they clearly do good work for the communities, but it's still coming at a cost when we start to do these exemptions to every other property taxpayer that's out there. I mean, the remaining property taxpayers are dwindling. And so again, we think it might be worthwhile to sit down and talk about these property tax policies to see whether or not they're fair, to see whether or not they can be modernized. There are many of these exemptions that went on board when we became a state. So I think it's time to look at that to ensure that communities have the revenues they need to provide services. And when I talk about services, I know it's sometimes very easy to talk about this quote unquote out of control municipal spending. But if you look at your own community's budgets, you'll see that there's a lot of that expense that's mandated. We have to pay for schools. We have to maintain roads. We have to manage solid waste. We have to do all these things. And our communities want other things too. Not only do they want good roads, they want libraries. They want parks and rec programs. So we're just asking when will be the right time to have a conversation about how we assess property taxpayers or how we assess property owners across the state so that it's fair and that we are all contributing to the services that we receive. So I thank you for your time and consideration, and we'll answer any questions you might have.
Thank you very much, Ms. Dufour. Does anyone have any questions?
May I just quickly, I don't want to be rude.
Oh, that's okay. I was going to ask a question. You go first.
Do you want me to leave and you call me back in, or do you want me to just quietly hover around?
Oh, you're coming in again?
Yeah, sorry.
No, I'll probably pull you out of this one, actually. But
okay, cool. Thank you.
We'll keep you on. I do have a question, actually, okay. Kate. Is there someone that you have, a lot of times different organizations will ask a legislator to put together a legislation to come up with a solution for something. Is there a discussion that you've had or that somebody from MMA has had about coming up with some sort of a, not necessarily reformulation, but a way to address these kinds of issues? When folks are asking for exemption after exemption after exemption, not that I'm saying that this is not the right one to do, but where can we get your input? How can we get your input to make things happen so it's easier on our municipalities?
Opportunities like this are good, just to explain our point of view. It's not that we're anti-exemption or anti any, profit. It's just to bring some sort of awareness that there's a cost associated with the exemption that is borne by remaining property taxpayers. So more directly to your point, we have had conversations in the past. We've engaged in working groups, but like any good working group, you develop a really good product and then it sits on a shelf and collects dust. So we've been the victim of shelving, I'll say. But I think, it relates to the last bill as well. If new property is going to be exempt, we're never going to grow. And I think we really have to have that conversation. And, maybe this year is not the year, considering we're all trying to survive a pandemic, but it's something we need to discuss in the coming years, so that we're all on the same footing, and that we're ensuring that, not just the property taxpayers are paying for these services, that we're all sharing in that burden. And, if every piece of tax exempt property paid just a little bit, our mill rates would go way down. So it's that conversation, and it has to occur not piecemeal. It has to be a larger conversation about what are the benefits, what and at what costs.
Right. Representative Gramlich.
Thank you, Madam Chair. Thank you, Ms. Dufour, for being here. Your answer to Representative Terry's question kind of piqued my interest and is prompting this question. So in the same vein of looking at the whole big picture in terms of tax policy, and certainly the implications that particular pieces of tax policy may have on municipalities, what I tell my students when I teach social policy is we always check in with our assumptions. And so I'm doing that. My assumption is that the Maine Municipal Association would also want to take into consideration the implications of municipal revenue sharing when we look at that type of calculus. Is that not so?
Yeah, you'd want to look at the entire package about, I mean, it gets back to how do we fund local government services? How do we do it? And what revenues are available? Right now, it's primarily the property taxes that are available. I mean, these conversations, somebody there mentioned the three-legged stool. I mean, we started these conversations about how do you tax mix between property income and sales, where the property tax is holding, 40, 42, 43% of that burden. So it's all part of that conversation. And I think it's an important one to have.
Thank you.
Any other questions? Seeing none, thank you, Ms. Dufour. I'm going to kick you out now. Next up, I believe, is someone from MRS. I thought Dr. Allen, but it looks like perhaps Mr. Sagasser. I hope I didn't catch you off guard, Mr. Sagasser.
On here. I'm sorry I had to leave and come back. You're addressing LD 198, is that correct?
Correct. Oh, and it looks like Dr. Allen is here.
Yes.
So you might be off the hook.
I don't believe we're testifying on this bill.
Okay, thank you very much. I appreciate it. All right. And Dr. Allen, that is fact. You are not testifying on this bill, neither for nor against?
I'm sorry. I left and came back, so.
So I'm so sorry. So I got a note that you were testifying neither for nor against for LD 198, but is that not the case?
Did Mr. Sagasser just?
He just said that you were not.
Which one, is this the Labor Council bill?
Correct.
That is correct.
Okay, my apologies. Thank you. Sorry, I may have read my text wrong. So back to lunch with you. Okay, so seeing that there are no other, there is no other testimony for LD 198, this hearing is closed on LD 198. And next up is LD 351. And Representative Foster, I believe, is going to be presenting this bill. Just let you in, Representative Foster. There you are, just perfect. Nice to see you.
Yes, good afternoon. I will try to get through this as quickly as possible because I'm sure you folks are ready for lunch. It's been a long morning for you. First of all, I would like to say good afternoon to Senator Chipman and Representative Terry, distinguished members of the Committee on Taxation. One housekeeping matter, I believe you received a spreadsheet that I put together, which I'll refer to in my testimony here this afternoon. I am Steve Foster, State Representative for House District 104, which includes the towns of Charleston, Dexter, Exeter, Garland, and Stetson. I stand before you today to present and in support of LD 351, an act regarding municipal valuation and state-owned property. During the 129th legislature, I was asked by the Town of Charleston Select Board to review their situation regarding the inclusion of the state-owned Mountain View Correctional Facility in their total municipal valuation and to offer legislation should it be warranted. As a result, I'm submitting LD 351 for your consideration. In Title 36 MRSA subsection 651, a list of city and town property tax exemptions includes subsection 1B, the property of the state of Maine. This bill proposes that the exemption would be limited to an amount up to 10% of the total municipality valuation. Maine's 2019 municipal valuation return statistical summary lists the property tax information for our 487 towns. In regards to a municipality's total land and building valuation, which is the number that I used in my research, state-owned property accounted for 1% or more of the total land and building valuation in 114 municipalities, 5% or more in 24, and 10% or more in only 14. I've included a list of those 14 municipalities with the testimony that I'm presenting. One of the 14 communities, Charleston, is home to the Mountain View Correctional Facility. This facility accounts for 52.9% of the town's total land and buildings valuation. Its 2020 valuation of $33,989,040 increased the town's net assessment for commitment by $545,524 to $1,016,421. Without it, the property taxpayers of Charleston would have paid $470,897. Unlike many of the other 14 towns where state-owned property accounts for at least 10% of the total, Charleston receives little financial benefit from the property. For example, municipalities with a university benefit from employment, spending at local businesses, community access to facilities, etc. Mountain View lists a staff of 170 employees. Charleston residents hold a total of 16 of these jobs, less than 10%. Charleston has no stores, no gas stations, or other businesses that might be frequented by employees or visitors to the facility. Last year, MVCF provided community restitution workers to Charleston whose man hours were valued at $18,012, the only theoretical in lieu of taxes payment. And by the way, surrounding communities also receive benefits from those work crews from the Charleston facility. The town provides fire protection with a small number of calls each year, including washing down the parking lots in the spring. It also helps fund the Penobscot County Sheriff's Office, which provides a portion of law enforcement coverage needed on nearby roadways where travelers to the facility may require it. Two of the towns in the list of 14 are treated differently. The state-owned property in Orono is exempted because the university was designated as a tax-exempt literary institution. The state-owned property in Limestone is not included in the town's total valuation. I was unable to determine the reason. There was a bill, LD 869, from the 116th legislature. Taxation committee at that time was chaired by former Senator and Governor Baldacci. But in the 116th, it would have reduced Limestone's valuation, but from the information I received from the legislative library, the only thing I could find was that it received a unanimous ought not to pass out of committee. Also, that bill would not have addressed the total exemption that Limestone realizes today. I hope from my testimony and the accompanying documents, this committee of the 130th legislature may find a remedy for Charleston's situation. I'm certainly open to any amendment to this bill that would do so, whether it's a change in the percentage of state-owned property that may be exempt, a method to remove the state's property valuation from the total, or some type of carve-out similar to what may have been done for Limestone. The town of Charleston and I would be happy to work with you to do so. Thank you for your consideration of this bill and would be happy to answer any questions you may have, and will make myself available for your work session. I would like to, if I may, address the spreadsheet with a list of 14 towns. When I put this together some time ago when preparing this bill, I used the total valuation of land and buildings to come up with my percentage numbers. This morning, while waiting for the opportunity to testify today on this bill, I recalculated using the total state-owned property valuation. And I will only say I will get that spreadsheet to you folks as soon as we leave here. I'll send it to your clerk. But one town changed enough to change the list, and that would be the town of Mercedes, which dropped significantly down to about 6%. So they would not be actually included in this, benefiting from this bill. No other towns in the list, and I also sent to the clerk for your review a spreadsheet of all of the towns in Maine showing the percentage of state-owned property in their municipality. No other town actually was boosted up to 10% or more, or above 10% of state-owned property by recalculating using that total property value. So I thank you very much for your time and the opportunity to present this bill to you. You'll see on the spreadsheet that Charleston, they're a farming community for the most part. And when you compare, for instance, their town to towns in York County or even the counties of Penobscot and others to some of our, what we would call more well-off counties in the state and municipalities in the state, they hold a significant burden, if you will, by having the correctional center there with no real significant financial benefit to the community. So thank you for your time.
Thank you very much, Representative Foster. Has anyone got any questions? I'm glad we gave you the opportunity to do a little extra work.
Thank you.
Thank you for waiting very long.
I appreciate that.
I appreciate it. Okay, so next up is Terry Lynn Hall from Charleston. Ms. Hall, you should be a participant, a panelist at this point, and just will need to unmute your mic and start your video, or just unmute your mic.
Can you hear me now?
Yes, we can. Good
Okay.
Good afternoon.
I'm not really good with technology.
That is okay. We can hear you, and that's all that matters. Thank you for joining us.
Okay, well, first and foremost, we would like to take this opportunity to thank the Taxation Committee on doing your due diligence in reviewing the bill LD 351. In all of the documentation that you have received, and the financial impact on our small community is enormous. Representative Foster just went over all the numbers, so I won't recap them for you as you've already had a very long day. But as taxpayers elect their officials to serve in Augusta, they entrusted all of you to do due diligence in representing them and completing the tasks at hand that you are assigned, always keeping your constituents' best interest at heart. As Mountain View has expanded over the past 30 years, their value has increased. Mountain View has provided restitution in Charleston, which is deeply appreciated, but they also provide those same services and more for all the towns surrounding Charleston. Since last March, restitution has been minimal because of COVID, which we totally understand because it's all for safety. On several occasions, Charleston officials have testified in Augusta for Mountain View to expand or keep the facility open. The town of Charleston and Mountain View have a good working relationship. The town of Charleston is not asking the state to do any more than any other landowner in the state of Maine is required to do in order to own property. The town of Charleston has always had a liaison between the facility as well as governor-appointed members to their advisory board and their board of visitors. The past 30 years, it has been a member of the Board of Selectmen, and that person has been me. I have served on the Board of Selectmen for 33 years in our community. But a brief synopsis of the town of Charleston. We are located about 25 miles northwest of Bangor. It has long been recognized as a bedroom town. The people that moved to Charleston is for the school district, the quietness, and the fact that Charleston is a close-knit community. We have no industry, no convenience stores, gas stations, anything of that sort. All the taxpayers of Charleston must travel for their employment, which is all by their choice, but they choose to do it in order to live in a quiet, connected community. As this current concern has been for our community for a very long time, we do want to express our gratitude to Steve Foster on sponsoring this bill. We as a community have been requesting this in excess of 30 years. So once again, thank you, Steve. But in closing, please keep in mind when you're voting on LD 351, the positive impact that will have on the taxpayers of Charleston. And we certainly thank you for your time and your consideration on Bill LD 351.
Thank you very much, Ms. Hall, and thank you again for waiting so long for us. Sometimes committee work can be very, very long. Has anyone got any questions? Excellent. Thank you very much. Again, we appreciate your testimony. Next up, we have, I believe that concludes all in favor of the bill. Yes, great. Thanks, Avery. And so next up is Mr. Sagasser from DEFS in against the bill. And welcome again, Mr. Sagasser, and apologies for bringing you in too early before.
No problem. Let me just get set up here. Okay. Senator Chipman, Representative Terry, and members of the Taxation Committee, good afternoon. My name is John Sagasser. I'm Tax Policy Counsel for the Office of Tax Policy, Maine Revenue Services. I'm here today at the request of the administration to testify against LD 351, an act regarding municipal valuation and state-owned property. The administration is concerned that the bill will create a lot of complexity in the valuation and assessment of state-owned properties. There are also numerous legal questions that would need to be clarified. The exemption may have a state constitutional underpinning that should be considered. In addition, partial exemptions should be narrowly framed to align with fair and equal valuation requirements. Further legal research would be required to determine the effects of these issues. Consideration should also be given to the intended classes of property to be covered by the exemption, given the legal difference between the state of Maine and its various instrumentalities. Valuation of certain state property may be very difficult, leading to disputes and uneven application. Also, property may still be exempt under another property tax exemption, for instance, literary and scientific institutions. It's also unclear whether the limited exemption in this bill is intended to exclude state property in the unorganized territory, which is not considered a municipality under the statute. Clarification of legislative intent, along with further legal research on that point, is necessary. On the technical side, we suggest the term equalized value be changed to just value to avoid administrative difficulty and align with the other property tax exemptions. The preliminary administrative cost for the bill can be absorbed within current budgetary allotments. The administration looks forward to working with the committee on the bill. Representatives from MRS will be here for the work session to provide additional information and respond in detail to the committee's questions. I'd be happy to respond to any questions you may have now.
Terrific. Thank you very much. Representative Sachs.
I was going to say good morning. Good afternoon, Mr. Sagasser. Your testimony actually raised quite a few questions, and maybe they will be addressed in the work session. The one I wanted to focus on here was the constitutionality question. Is that something that you can briefly address now, or again, would you prefer to do all of the issues you raised in the work session?
I would just throw a little light, but it does take little research. There's an indication in the case law that there's a constitutional sovereign immunity for the state, regardless of any statutory exemption. And as such, for the sovereign immunity, there'd be questions about if there to be waiver, what's the manner that would be done, issues of how would enforcement by a town against the state look like, what would be the framework for that. So the basic point would be the constitutional immunity, sovereign immunity for the state itself from suit and actions.
From paying property tax in this case.
Well, yes, in twofold. As far as the tax, it being taxable, and also as to enforcement of a tax obligation.
Okay, so I'll look forward to the work session for maybe some additional information.
Okay.
On your testimony. Thank you.
Thank you, Representative Sachs. Any other questions for Mr. Sagasser? Excellent. Thank you very much for your testimony. You're free to join your lunch plate again. Okay, so that is it for those against testimony. With testimony, next up is Kate Dufour from MMA, who is here to testify neither for nor against. Welcome again.
Thank you very much. Representative Terry and members of the Taxation Committee, my name is Kate Dufour. I'm here on behalf of the Maine Municipal Association to provide testimony neither for nor against LD 351. And providing testimony neither for nor against because our policy committee has not established an official position on the bill yet. But in order to prepare for this hearing, we did poll our members to get a sense as to where they might land on this particular issue. And the results thus far, they're not official, but illustrate that our membership is torn, and they're torn on two fronts, obviously. The first is with respect to municipal officials understand that there are some communities in the state that have a disproportionate amount of state property within the municipal boundaries. They get it. I mean, I understand some of the issues that were raised, but if you look to an Augusta or you look to an Orono, you'll see that they do have disproportionate portion of Maine state property within their borders. So they get it. And that's an issue that should be addressed. The concern is, how will that get addressed? If the state is supposed to pay taxes to a few communities, 10, a dozen, whatever it might be, how are they going to pay for those for those tax assessments? And the concern, that the other side of the coin concern from our members is, will that come out of revenues that are already dedicated to municipalities? Are we going to, what's the phrase, rob Peter to pay Paul? And there's a concern that those revenues might come from the revenue sharing program, which are now being shared by all communities. So that's where we are at the moment on this particular bill. The policy committee will be taking a full review of it on Thursday, and I'm happy to submit follow-up testimony should you find that valuable.
Is that this Thursday, Kate?
It is.
So you'll be ready to come to see us at the work session with a little more info. Okay.
I will.
Yep. Terrific. Does anyone have any questions for Ms. Dufour? Excellent.
Thank you.
Thank you very much. And thank you again, Representative Foster, for sticking with us for so long. You too are free to join your lunch plate.
Thank you. Thank you very much.
And that ends this public hearing for LD 531. We have one last thing to go, LD 149, right, Avery?
146, and it was LD 351 that just ended.
Oh, did I not say that? I'm sorry.
531. It's okay.
Sorry, I have just the littlest bit of dyslexia. Not a joke. Okay, let's see. So LD1.
We have Peter Lacey.
Excellent. Thank you so much. Mr. Lacy, thank you for joining us. And again, thank you for staying so long. LD 146 has to do with the unorganized territory, correct? You're all set, Mr. Lacy, whenever you're ready.
Thank you. So Senator Chipman, Representative Terry, members of the Taxation Committee, good morning. My name is, or afternoon now, I guess. Sorry, I prepared testimony earlier. My name is Peter Lacy. I'm Director of the Property Tax Division at Maine Revenue Services. I'm here today at the request of the administration to testify in support of LD 146, the resolve authorizing the state tax assessor to convey the interest of the state in certain real estate in the unorganized territory. So this is an annual agency bill being proposed, which allows the state tax assessor to sell properties that were acquired by the state through the tax lien process. So Title 36, Section 1283 requires that the state tax assessor report to the legislature all property in the unorganized territory that has been tax acquired by the state and after authorization by the legislature to sell that property. This resolve is a statutory step in that process. The properties listed in the resolve were acquired by the state through foreclosure of tax liens for non-payment of property taxes. None of the properties, I will note, none of the properties included in this resolve are occupied homesteads. This process is a routine element of unorganized territory tax administration, and the administrative costs can be absorbed within the current UT budget. The general fund is reimbursed from the Unorganized Territory Education Services Fund for the costs of property tax administration in the unorganized territory. I will note we're requesting one minor amendment to the bill to reflect some corrected numbers related to one of the properties contained in the resolve. I believe that was sent to Avery earlier, so you hopefully should have it. The administration looks forward to working with the committee on the bill. Representatives from MRS, including myself, will be here for the work session to provide additional information and respond in detail to the committee's questions. I would be more than happy to respond to any questions you may have now as well.
Thank you, Mr. Lacy. Just for new members to the committee, this is something that we see every year. We are part of the, I guess one of our functions is to make sure that everything in the, we're sort of the tax assessor, I guess not really tax assessors, but we're part of the group that makes sure that everything in the UT gets done as a municipality would do. So going through this list, which we actually received quite a while ago, you all should have received this in your emails. I'm going to say at least 2 weeks ago. Julie can probably tell us a different date if that's not correct. But my question always is there somebody living in these homes? And Mr. Lacy, you seem to have addressed that already, that these are all unoccupied at the moment. So my only question is, have you had any discussions or disputes with any of the property owners in any of these properties over the course of the year?
I mean, we spend quite a bit of time reaching out to these taxpayers and attempting to, work them with payment plans and get them on track. No, we are not currently. A lot of them are ones that we cannot find.
Cannot find the property owners.
Correct.
Okay. Gotcha. Anybody else have any questions for Mr. Lacy? All set. Thank you very much for your testimony.
Thank you very much.
Avery, do we have anybody else on the list who would like to speak neither for nor against?
Nope.
All right, terrific. Then we are all done. That closes the public hearing on LD 146. I have nothing. I'm too hungry to think. Does anybody have any last minute thoughts on the day?
I move we adjourn.
Second.
Excellent. Noted. This meeting